campaigns, 11%. We also took a look at different projects that were done from Women Affairs and raised other strategies to improve sexual and gender-based violence as well. Part of what he raised was to ensure that budgets reflect the objectives of the agencies receiving them, to increase, of course, funding for justice and social welfare activities, and to engage ministries and agencies with clear policies and roles. There were questions and answers that came from the audience. We had several questions and answers. I'm running out of time because I can't take all of it as part of the recap, but I do know that, for example, Aisha M. Gauje from Sokoto also gave an additional comment stating that both the Ministry of Justice and Judiciary should shoulder the financial burden of witness support, because there was a whole lot that talked about the burdens coming from witnesses not being able to come to court to, of course, give statements, of course, against the accused. Then we had panel discussions on integracy, coordination to address sexual and gender-based violence. We looked at what was working, what was not working. We had Honorable Justice Raman Oshodi, who is also here, who talked about specialized courts. He talked about the states, that's Lagos State, having specialized courts, including family centers and specialized offense courts, which feature a crunch unit to protect child victims. He also recommended that victims are, of course, encouraged to use these courts to better support the justice system. Honorable Justice Oti, who was also on the panel, talked about specialized courts as well in Anambra State. She talked about the gaps identified. She said more foster homes are needed for child victims and youth education on ritual-related rape, which must be prioritized in Anambra State. We had Mr. Lawal Huda Garba, who talked about collaboration, coordination between the Chief Justice, the NGOs. NAPTIP has facilitated justice for victims with 17 cases treated through these partnerships. And we had Aisha Koje also talking about judicial assignments as to sexual offenses being assigned to female judges, ensuring appropriate conviction. Yes, we did get some comment saying that it's not necessarily just females that would do a great job, in that men as well, who are equally sympathetic to the needs of women, could equally play a fantastic role there. We had Mr. Felix Awoni, who equally talked about prosecution integrity, that the government needs to ensure that once cases are prosecuted, there's no interference occurring. Then DCP Rita equally talked about the commitment of the police leadership and talked about the Inspector General showing dedication to combating GBV and calling for the police forces to prioritize these responses. As to what was not working well, again, rehabilitation gaps, compromise and cultural issues, police training, more trainings need to be done. Culture of silence was mentioned, mobilization challenges. We also had issues of judicial capacity, still linking again to more trainings, police logistics, witness mobilization, medical experts, delays in courts, which also discourage medical doctors from presenting critical evidence due to their professional priorities. Takeaway was that while strides have been made in establishing specialized courts, fostering integrity, fostering collaboration, and enforcing the VAP law, significant gaps still remain in training, logistical support, and cultural attitudes, and to, of course, prioritize funding, advocacy, and reforms are, of course, essential to overcoming these challenges, and also to ensure that justice for SGB survivors is seen in Nigeria. I believe that I have done a very quick recap, and I hope that basically made sense. Okay, because we're running out of time, we need to move swiftly to our next session. But like I said, I will be recognizing our other guests coming in. Now, to take us to a wonderful, wonderful session on beyond enacting legislation, requirements, guidelines, protocols, and process. Please allow me welcome again to the stage with a round of applause from the Lagos State Judiciary, my Lord Honorable Justice Rahman Oshode, to take this session. A round of applause for him. Thank you. Thank you. Let's keep it coming. Thank you.
Your Excellencies, distinguished guests, ladies and gentlemen, permit me to leverage on the existing protocol and also to wish all the men here today happy International Men's Day. It shows that men also add positive value to the world, including SGBV. My presentation is about, in a nutshell, outside laws and outside legislation, how can we fight SGBV? Throughout this presentation, I'll give examples of what we have done in Lagos and what everyone should do in respective states. I would want a situation where at the end of the presentation, we take home one or two things. So I've given 4 recommendations. The first part of my presentation is specialized court. It's important we have it. We discussed that yesterday. We are discussing that today again. The second is comprehensive investigation protocol. It's very important. I'm happy we have the SARCs here. We also have investigators here. The third is the jurisprudence on corroboration. Corroboration simply means support evidence. Then the fourth part is how to use technology in the fight against SGBV. I'll start this presentation with a short story, and I'm sure you can Google to read about it. It has to do with the Martin trial in the US in the 80s. Now, it was a preschool trial. It was a school where a lot of young boys and girls had been abused, hundreds of them. And they set up an investigation. It cost the American government $15 million. The investigation and prosecution lasted approximately 6 years, from 1983 to 1990. And all of that, with all the resources spent, there was no single conviction. Now, and it's sad, boys have been sodomized, girls have been abused, and you can see the evidence right there. At the end of the day, nobody goes to jail. And as a result of that, they decided to develop protocols for investigation so that that mistake would not happen again. We have the same problem in Nigeria. I will explain the case of ICO and the state, even though we don't have a legal audience, but I've tried to put the facts so that the audience will understand. In that case, too, a 16-year-old girl was violently raped by a taxi man. At the end of the day, the man was discharged. So this is the reason why it's important we have this discussion. That takes care of my introduction. I'll go to the next part. The imperative of specialized court. Now, I will just describe with this picture. You can see the former chief judge, the former deputy governor of Lagos State in 2018. They built this court specifically for special offenses and sexual offenses. Every aspect of the construction, including little details like putting flowers around the courthouses, having a creche, all of it is contained in that courthouse, and that's where I said we have 6 courts. To do this, we don't require laws. All we need is the goodwill of the system. Recently, all the Honorable Chief Judge needs to do is to write a letter to the Honorable Judges to say, I have hereby appointed you as sexual offenses court judge. Give a directive to the head of the administration in the litigation section of the court to say, I have now appointed 2-3 judges to sit in the specialized court, sexual offenses court. Then also write to the Ministry of Justice to say, for SGBV cases, have a special color of jacket, file jacket, so that the people in the registry will not mix the files together. We have that in Lagos. We have purple files, we have pink files, we have brown files for different subjects. Then lastly, then have a meeting with the honorable judges. And we've had this meeting in Lagos to say, if you're a judge and you're in the Lands Division and you receive a case file on sexual crimes, make an order referring the case back to the admin judge or the assigning judge so that it will go to the proper court. Because we realize a lot of defendants, because they know it's a specialized court, they try to go to the court registry. They pay them money so that they give it to the wrong judge. If we put these 4 things in place, we do not just establish the specialized court, we also ensure that the process is followed in detail, that the judges get it. Then apart from that, having done that without any law, we also now need to train our staff. My staff are so well trained because they've been just sitting in that court since 2018. If a defendant is in the dock and a little girl wants to give evidence, sometimes when the defendant looks at the girl, he doesn't give evidence. She won't say anything. And so my registrars are so well trained. The moment they see that kind of scenario, in fact, when the girl is about to come in or the child is about to come in, they tell the defendant, face the court. They direct the way he's going to sit. That is part of the nuances and training they require. I have a stenographer who is so well trained that, we don't expect children to begin to say penis or vagina because they don't know these things. Some of them are as little as 4-year-old. And so when they say bomb, the prosecutor will say, is it your front bomb or the back bomb? The girl will say front bomb. Then they will now say, can you show us the front bomb? The girl will point somewhere. Now, a lawyer tried to confuse me in his closing submissions in one of the cases I tried. And he said the girl pointed at her lap region just to confuse the records. But my stenographer, seeing what the girl had done, said the girl pointed towards her vagina. It was verbatim record of proceedings. Every single thing said is captured in the proceedings. And so it directs the court on what to do. So apart from setting up the court, we need to also train the personnel, the judges, and the training is high-intensive training. The judge would know how to put the preliminary questions to the witness, to the child. Because a child cannot come to give evidence in court, and the first thing I say is that, okay, what did you come to court to do? No, you start with the very soft questions. Your name, every child is happy to say the name. What class, the child, they're happy to say their class, they're happy to say their school. When it relates to their friends, they're happy to say, oh, my best friend is A or B. Then you ask, why didn't you go to school today? Some are very smart. They say, I've come to court to give evidence. Those ones are highly intelligent children. And some will say, the moment you can satisfy those, but not all of the judges will understand this because they've not been trained. So specialized court is not just the courthouse. The personnel must also be specialized. I move to the second part. Then also, I must mention, and I think I mentioned this in the earlier training, to say that the specialized court is also tailored in such a way that you have video conferencing, you have a creche, you have video conferencing there, because some of these witnesses don't feel comfortable testifying in court, so you can activate it. Video conferencing don't cost anything. We have 20 Zoom licenses. I think it costs $15, $20 for a year subscription. It's not expensive. And so the goodwill of the system will enable that to happen. I've seen cases where witnesses won't give court in open court when they see the defendant, but when we put them in a private room, they are looking at the TV, they are able to speak and express themselves better. It's important, as you will see later in this presentation, there were cases where the witness did not describe the incident well, and the court nullified the entire trial. The defendant is back on the street in Abuja. We'll go to that case shortly. Comprehensive investigation protocols, which is also another very important part of no law, but we can have a comprehensive investigation protocol. Now, for you to have the system we currently operate in some states that don't have specialized investigators is ad hoc. So it depends on the mood of the police officer. So a woman goes to the police station to say, oh, they have just done this to my 3-year-old daughter. If the policeman is happy, he takes the statement. If the policeman is not happy, he may do otherwise. I've given 3 important examples to explain, to drive this point home. And these were practical. 2 of those cases were cases that I presided over. One presided over by another sexual offenses court. The first case, I've given them easy names for easy understanding. The first case is the case of the kerosene hawker, 2017. Then we didn't have some of the things we have now. So this incident happened on the 1st of May, 2017. By the way, I must let the prosecutors and investigators know that the moment a child comes to the police station the first day, you begin to ask important questions. When did it happen? Was it a school day or a non-school day? And this will help you to determine. It will also be helpful in court. So in this case, she didn't go to school. It was May Day. So she had to go to her normal, to hawk kerosene. So she was at Obanikoro doing the normal business. Then a security guard stationed at an insurance company, I didn't mention the name in this, called her to the premises and in the guise of trying to buy kerosene. Once inside, he took her into the driver's office where he sexually molested her, rubbing and sucking her breast, and forcing her to do the same to him. He also examined her private part under guise of checking if she was menstruating, because the girl said she was menstruating, and so when she began crying, it attracted another security guard. The survivor eventually left, and the case was reported. That's not the issue. When the case got to the police station, the initial response was deeply problematic. Instead of focusing on the sexual assault, the police arrested her mother and detained her for allowing her daughter to hawk kerosene, as documented in the judgment, because I reproduced the extract of her transcript in the proceedings. This was what she said. From there, they now take us to, sorry, the grammar is not mine, but we have verbatim, so you have to say it as they say it. From there, they now take us to the case to Pedro Police Station. And from there, they said they should find the defendant. Even at that night, they locked me in the cell. She further stated, I have to bail myself. This punitive approach to the survivor's family demonstrates systematic failures. Now, what later happened? She was a nanny, and so she didn't go to work because she was in custody overnight. And when she reported to work the 3rd day, the madam now questioned her, and luckily, a very influential madam called the police, and they escalated the matter. Eventually, the defendant was tried. He was convicted in September, 30th of September 20. Unfortunately, the defilement charge did not hold, but he was convicted for sexual assault by penetration as well as assault, which is 7 and 1 years imprisonment to run concurrently. The second, which we all know, is the Baba Ijesha case, 2021 to 2024. Now, there is the perception that Baba Ijesha was a celebrity, and that's the reason why he accorded that much attention. As you will see, it is not. Now, in that case, we had everything in place as of 2021. And so everything went perfectly well. The investigators, the prosecutors, even the video of him trying to assault this girl was preserved. Before, they would not have preserved the video. And everything went in place. Eventually, proper protocols were observed. Before I end this section, I'm going to give the protocols in a nutshell. We immediately deployed. Forensic interviews were conducted. Evidence was systematically collected. I think the forensic interviewer, I think I met her earlier today, a child forensic interviewer was applied. Eventually, Baba Ijesha was convicted by the trial judge. His conviction was upheld in June of 2024. Sexual assault by indecent treatment of a child, it was 5 years imprisonment and one other count of 3 years imprisonment. The Court of Appeal delivered the decision, and it shows clearly that upholding the decision of the trial court. For those that believe or think that it was because of Baba Ijesha, I have a case of an orphan domestic staff. She was 13. From her evidence, she does not know her father's whereabouts. Her mother died. she stayed with her aunt. They were quite, I think, two of her siblings. They were three with her aunt. And she couldn't take care of her, so she brought her to Lagos as a domestic staff. She had absolutely nobody. In fact, the madam she was working with would never even allow her to speak with any of her relatives. But eventually, she was assaulted by the madam's son, who was much older. He was in his late 40s, thereabouts. Later, he left the house, but he continued to go back to the house to assault the young girl. The father, they repeated it. The girl got to school one day and told her teacher, to show you the sophisticated protocol in Lagos, that she no longer wanted to go to school. Then that's a red flag. Teachers have been trained to understand it. The teacher interviewed her, realized that it was because, she now disclosed that it was because of the assault that her madam's son keeps assaulting her. And after the interview, the teacher took her to the school counselor. They called the social worker. It was, in fact, when the girl gave evidence, smart, because when they were discussing how to get the girl, she said, I know how to get the defendant. So she too participated. So what they did was that when she now saw the man again, the abuser, he said, Oga, bro, give me your phone number and your address. I want to come and see you in the house. So the man was happy. He assumed that she was enjoying it. So she went back to school, gave the teacher the address, then the teacher called the social worker again, then they planned. So they gave her a phone, she called the man. They went to the house, they were outside, she went in. As soon as he opened the door, they all rushed in and arrested him. It was a clear, systematic approach. And when the aunt came to testify for the defense, she didn't seem to understand. He said, but she's my child. I can do whatever I want with my child, and I don't even know why these people are disturbing us, that I want to take my child back to the East. But no way. She became a responsibility for the government. And I must particularly give the Royal Diamond Orphanage in Ogba. They were the one that took the girl. They kept her throughout the period of the trial. And that is also demonstrates the systematic approach, because the moment the social worker got involved, they looked for the nearest orphanage if they didn't have any place in the government-run institutions. All of that played out. At the end, the defendant was convicted earlier this year and sentenced to life imprisonment. But this girl had nobody. Then I have one other case. It's in the footnote. That was Adeleke Adebanjo, a couple, senior citizens, a 9-year-old girl. She didn't know her father because her surname was Alaji, because she said her father's name was Alaji, and so her surname was Alaji. Abused by the couple. But guess who reported the incident? We have mandated reporters. They are in every local government. They have a WhatsApp platform. The lady observed the way they were treating the child, reported to the police. This child had nobody. This case to the mother came. The mother wrote a withdrawal letter to the court. It's the responsibility of the government. And that's what a take-home. If a child is involved, that child is the responsibility of the government. Government must provide. If you don't have the means to provide, then there are NGOs willing to assist. I mean, for those NGOs, I must continue to appreciate them, because they spend their time, their money to take care of children that are not theirs. And some of these children, by the way, in this lady's case, at sentencing, they offered to pay compensation. I made a compensation order, and it was for 1 million naira in care of the NGO. And because it was an alternative sentence, that same day they paid the 1 million. And of course, the NGO now has 1 million to keep in care of the child, which also shows that all of these systems, if effectively applied, will bring justice to the vulnerable victims. Now, this second part from paragraph 17 is for the prosecutors and investigators. The need for robust trial preparation. A lot of people that do government work assume that government work is a place to rest, but it is not, because government work is service. If you don't think you want to do public service, then private work is more profitable. And so people that do government work have the tendency of not taking some things seriously. It happened in Abuja, FCT, Abubakar Mustafa Dankara and FRN. So every public officer, whether the prosecutor, whether the defense investigator, you must be on point. The case, you must rehearse the case over and over again and make sure you present the best evidence. It's a sad case, a sad day for the law. In that case, a young boy was sodomized. The perpetrator penetrated his anus. It was arraigned under the VAP Act. It's not just about laws, and it demonstrates it's not just about laws. The prosecution was so confident. They had all the witnesses. They had the IPO, they had the medical doctor, they had the boy, the victim, they had the victim's mother, so they thought it was a case they could never lose. But they didn't prepare well. They probably went to sleep at some point. But not to bother you, I don't want to go through the alibi defense, but they didn't produce sufficient evidence. And I've extracted that part, and I want us to read together. Where the boy said, where the prosecution dropped the ball. This was the boy's evidence. On Saturday, after Isemiya, I went to my friend's house, Sudias. I knocked at the door, and he opened his door and said they were not around. He now asked me about my brothers and sisters. He dragged my head and forced me into his house. He brought me water to drink. When I drank it, I started feeling dizzy. He now removed his trouser and my own. After I finished what he was doing, he told me to go home and not to tell anybody. It was reproduced by the appellate court. Oyewole JCA gave the lead judgment in July of this year. The said PW to the victim did not explain what he meant by after I finished what he was doing. That was why they lost the case. The Lagos State prosecutors are well trained because they say, what do you mean by after I finished what he was doing? The Court of Appeal found that this testimony was not sufficient because after I finished what he was doing, failed to establish the crucial elements of the penetration. And that's the reason why when I have this, you must say it as it is. This shortcoming in evidence presented could have been prevented through proper witness preparation and more detailed examination in chief. The man also gave a defense of alibi. The police did not investigate it. Alibi is simple. A crime occurs in Lagos, and I'm here speaking today. Police invites me to say I should come and give my response. I'll be happy to go back to Lagos tomorrow and say I was here. I was in Transcorp. I have my room number. I flew Ibom Air. I have my flight ticket. And so every reasonable police officer who must follow the protocol, the first thing is to call Ibom Air to see whether I flew. Next thing, they call Transcorp, whether I stayed there. Then third thing is, oh, where is the program for the event? I have it here. And I'm going to show the police officer. The next thing after that, well, they should let me go. But if the police officer is not still convinced, then they will call the gender section in Abuja and say, please, can you go to Transcorp to find out if he actually slept in that room? Once the alibi has been investigated and is confirmed to be true, they must let me go. That is the law. Now, repeat offenders, people that have been to custodial centers and they come back again, they know these things because they've been to court several times. They receive training, different levels of training from the custodial center. So when they go, they just give a fake alibi. I was in Ibadan. The police will say, write your statement, endorse. They get a medical report. It has confirmed that he did it. They charge him to court. Ladies and gentlemen, failure to investigate alibi, once it is raised, it's an escape route for defendants. We must let them go because the police did not do their work. We try to prevent these failings in Lagos State, and that's why they set up the Child Forensic Protocol. I must recognize the Sierra Foundation. They are at the top of it, trying to establish a robust protocol for, and they are trying to also codify it. We use the protocol on ad hoc basis, but then they are trying to go to the house to make it a law that you must comply with this protocol. If you comply with this protocol, you can never get it wrong. I've said that the investigators must approach each case with an open mind. They must investigate every lead. They must properly document the evidence. They must preserve all potential evidence. Since I've sat in the sexual offenses court, I've never received hard evidence, real evidence. Torn underwear, torn clothing, I have not received one. Then if the police receive this evidence, why can't they just take pictures? I have not even received the pictures. So the woman will say, I gave everything to the police. Where did the IPO keep it? Cannot be found. Vital pieces of evidence. At the end of the day, the defendant is discharged. They blame the court. They say it's corruption. But if you don't do the work properly from day one, then defendants will go free. I'll give you statistics to show how many of them we have let go. Almost 80%. Yes, and they are back. Some of them are our security guards, our drivers. I don't believe in security anymore because I've told the analysts to come to my court. We want to identify all the cases involving security. They are number one offenders, particularly with children. Security, religious leaders, then school teachers. I'm already there. The data from one of the courts, that's my court, there's a concerning trend of outcomes of these SGBV cases. 65.8%, an accurate figure because I checked it myself. Then when they did the schedule, I had to look at it. Then we updated it as of 15th of November, which was last week Friday. 68.5% struck out due to failure to find the defendant, because that was what happened in the past. Those cases of 2013, 14, the magistrate grants bail, defendant jumps bail, we can't find the defendant. Then some, 2016, 17, 18, the complainant, you can't find them anymore. Along the line, there's compromise. So 65.8%, they didn't even have to answer a case at all. Gone. But luckily, with the plea bargain, 5.2% of those cases, yes, they embraced plea bargain and they were convicted. Then we have a conviction rate of about 10%. Now, when I say 65.8%, of the concluded cases, there are some that are still ongoing, and it's of 537 cases in approximately 4 years. So the 65% is of 537. And so if you add 65% plus those that have gone, which is approximately, okay, it's all in this table. It's all in this table. Conviction is 10.5%, discharge 18.5%, plea bargain 5%. So what you need to do is to add 18.5 plus 65. That takes us to over 80%. 80% of 537 gone. And they leave the custodial center, they come back the next day. The easiest work they take is security because they don't have a place to sleep. And so if you give them security work, they will sleep there. Then some, those that work with private security, they will enroll in 2 private security companies. So when they sleep in your own house for 1 week, their off day, they're in another person's private security house for another 1 week. They do that. With this experience I have, my brother employed a security in Lekki. And the first day I visited him, he spoke so well. And I told my brother, this man is too qualified to be a security man. And I asked him, interviewed him briefly. He said, my name is James Brown. I said, you are from which state? He said, I'm from Ondo State. I said, don't you have a traditional local Yoruba name? He said, no. I told my brother, this man is a criminal. He said, oh, you have started the game, my lord. About 2 months later, he stole diesel and they caught him. The driver caught him. So, well, he was still pleading. So they kept the diesel aside and said, okay, we'll call your security man, the company to replace you. That same night, he scaled the fence, went to the neighbor's house and stole their own diesel. Then they caught him again. And when they caught him, they were looking for police. In the midst of the confusion, he ran. They chased him, he ran away and he disappeared. I said, this man is a repeat offender because he must have been convicted. He removed his name and used James Brown. And so he will go again and go and do another security work. Then we'll pay them 70,000 naira monthly, but we are paying criminals And that's the reason why we have this in Lagos now, because once we convict them, we take their biometrics. And so wherever they go, we can check, and we'll find out if they are first offenders or not. So, well, all of this have to do with preparation. You must prepare. What I've told the prosecutor, I wish they were here, they must also anticipate the defendant's defense. You don't just prepare your own case, you anticipate their defense. The prosecution must guide witnesses to provide clear, specific testimony that leaves no room for ambiguity about essential elements of the offense. I'll get there later. Then I've said that the Dankara case demonstrates that successful prosecution requires detailed attention. Some lawyers will say the court should help, but courts are bound by precedent. So I can't help you. Because if I try to help a person today and I twist the law, then I set a wrong precedent for myself. Then tomorrow, I have to follow the wrong precedent. And so courts are bound. Then, of course, there's the jurisprudence that says if a Supreme Court or a Court of Appeal gives a decision, I'm bound to comply. Dankara's case, I must comply with it. If I find a similar situation, legal situation in my court, I must comply. Unfortunately so. So the work is for the prosecutors and investigators. We will do our own part of the work. There must be comprehensive preparation. The prosecution can ensure that SGBV survivors receive the justice they deserve and that perpetrators are held accountable for their actions. Don't ask the court to help you. Do your part of the work. We'll do our part of the work. I've now gone to evolution of investigation protocols. I've said that the 3 cases I identified, the kerosene occur, Baba Igesha's case, and the orphan domestic staff, demonstrate the remarkable transformation. See how we have moved from 2017 to 2020. Now we are even more sophisticated. In Lagos State approach to investigating LGBT cases, the system has evolved from one that criminalized a mother for a child's hawking while ignoring sexual abuse to a sophisticated mechanism that delivers justice regardless of the survival circumstances. I must emphasize that point. A lot of victims that come to give evidence today have absolutely nobody. But the system protects them, and that's the best the system can do for them. And that's what every state must take home. Because these young girls will survive. Yes, they will survive, they will succeed. They will get married to our children and the young boys. And so we need to ensure that we develop them. As a result, they become good members of the society, notwithstanding what has happened to them. I'm also advocating that the offenders, we should go to custodial centers and also reorientate them, counsel them. We've been making such orders now with the aid of the Domestic and Sexual Violence League. They go to the custodial center because they know that 80% of them may still get out. They train them, they reorientate them, counseling, so that when they even come out, they do not go back to such act. I've said the current framework emphasizes a coordinated, survival-centered approach, and we must prioritize the survivor's safety. Medical examinations must be promptly conducted. They must be adequately documented. Evidence must be systematically collected and preserved, which is important. Most importantly, survivors receive comprehensive support throughout the justice process. I've gone to talk about the child forensic interview protocol. It's a protocol, whether we have it codified now or in the future, let's have a book where all investigators must read and apply. If we can't develop it as a book, let's have it in bullet point so that they can, or a handout, a short document that shows how you must take every child survivor, because these children go through a lot. They are the ones that lack capacity to express themselves. That interview is very important because usually the video is tendered in court and we can use it as corroborative evidence. Well, not to say much about that, I've said a lot. I've said that the crucial element of the current position is the requirement for coordinated agency response. When a case is reported, it triggers immediate action from a network of responders, first responders, law enforcement, medical professionals, social workers, domestic and sexual violence agency, and special prosecutors. I call them special prosecutors because they are special. Now, the way it works,
is a complaint may emerge from the home, from the school, from any other place. And so all of these work together. And in the past, a regular SGBV case, we usually would take 4 witnesses: the victim, the parent, the police, IPO, the medical expert. But now, witness testimony platform is increasing. We have staff of the Domestic and Sexual Violence Agency coming to give evidence. We have social workers now constantly coming to give evidence. And a cocktail of this evidence builds a case for the prosecution. And this is what it's advisable all the states follow. It ensures the evidence is properly collected and preserved while survivors receive necessary support and protection. Now, I've said how we have transformed the Lagos from 2017 to what we have today. Another vital point of this presentation, which is quite technical, is evolving jurisprudence on corroboration. Corroboration, I think we should take away corroboration and just call it support evidence. Every SGBV case requires support evidence because it is I say, you say. There are 2 conflicting evidence. He read me, I did not. Who do I believe? I need other pieces of evidence, and that's what we call corroboration, support evidence. Now, this is where I will discuss the equal and the state. It happened in 2000, and the Supreme Court decision was in 2001. I said the jurisprudence of medical evidence and corroboration in SGBV cases has evolved significantly since the landmark case in Equal and the state. What happened in this case? The appellant was a taxi driver. The survivor's father had him transport the 16-year-old daughter to school, boarding school, because the evidence showed that she was carrying a bag of garri, a bag of books, and a bag of her clothes. So she had a lot of luggage. Despite her protest, the appellant drove the survivor. That the appellant means the offender. Drove the survivor to his home, but she resisted. He later raped her in the car. The court, and I don't know why prosecutors don't read this case, because if they read this case, they won't be making the mistakes they are making today. The Supreme Court educated the public, they educated the lawyers, the judges, and prosecutors in this case. But we keep dropping the ball. This was what the Supreme Court held in that case. They went to town and evaluated the fact to show that they know that he did it, but the prosecutor did not. It's important we read this quote. When they got to the defendant's house, they at home, the PW1 is the victim, removed her luggage, but the accused is the offender, collected them from her and put them back into the vehicle. He deceived her. He was taking her back to where she lived. Instead, he took her to an isolated, who is from Akwa Ibom State, they call it Akpan Essien Street. Yes, in the rainy evening, it was raining. There he stopped, wound up the glass in the door of the vehicle. He started to struggle with the victim. The victim resisted. But the resistance was short-lived, for it was not long before the offender overpowered the victim and removed her pants, inserted his penis into her vagina, and had carnal knowledge of her. There is more. He drove her back to his house and was prepared to make her spend the night there even after the first round of sexual intercourse. He left her in his house and went to park his vehicle. During that time, the girl ran away. She went to a neighbor's house. The neighbor was PW4 at number 5, Effiong, Upong Street. She slept with the neighbor's house, and the following morning, she went back to Calabar to report to her father. With all of this, you would think a case has been established, but no. The legal standards extremely tough. We can't drop the bar because of SGBV, because it's a constitutional right. A defendant is presumed innocent until after proven guilty. Any reasonable doubt must be resolved in favor of the defendant. All the defendant needs to do is to create reasonable doubt. Significantly, in this case, this was where the prosecutor made the mistake. There was evidence that after the incident, the appellant, accompanied by his father and the vehicle owner, visited the survivor's father to beg for forgiveness. The survivor's father testified that during this visit, the appellant admitted to forcing himself on his daughter. However, this admission would have constituted corroboration if adequately evaluated by the trial judge. So the court didn't evaluate it. The prosecution did not remind the court. Now, in Africa, unlike in other parts of the world, we have a begging tradition. When somebody does something wrong, they usually come to beg. I used that case in one case where the defendant raped a 13-year-old girl. The prosecution did not lead evidence regarding the oral confession. But when they put the girl's father in the witness box, the way the defendant counsel was cross-examined, the man became so angry. And he said, but they came to beg me. He came with his pastor, he came with his family. In fact, his lawyer came to beg me. They asked me to sign an affidavit that I should withdraw the case. That evidence given under cross-examination was extremely compelling. And that was what caused, because it was the incident happened a long time ago. And so when the girl testified, some of these young girls don't understand the impact. So she was just smiling, so our evidence was neither here nor there. But when the man gave that evidence under cross-examination, it was compelling because the prosecution didn't prepare for it. The reason why they say so is that the man didn't prepare to say that in the witness box. That's why there is jurisprudence to say evidence gotten during cross-examination are more compelling. The offender was eventually convicted in that case and was sentenced to life. Subsequent cases are built on this foundation. Ogumbayo's case, 2007. So when they made that mistake in 2001, it was corrected in 2007. The Supreme Court held that medical, and in that case, in Iko's case, the prosecutor also failed to tender the medical evidence. And so all of that combined to the failure of the case. Now, prosecutors always believe it's only the medical doctor that can tender it. It's not correct. We have so many cases. Balogun and the State, 2022, Supreme Court. The IPO can tender all the documents that form part of the investigation case file. The IPO tenders it, and the court can read it and use it. However, it's always good to have the medical expert give evidence, depending on the circumstances of the case. So perhaps they could have asked, and because the Evidence Act is structured in such a way, recognizes that the medical practitioner may not be available all of the time. And so Section 50, Section 55, Section 39, 41, all give exceptions to documentary hearsay. Prosecutors don't understand this. They don't use it all of the time. But regardless, in Ogumbayo's case, the Supreme Court held that medical evidence of fresh laceration to the hymen was sufficient corroboration. So there is established jurisprudence now. Medical evidence is corroborative evidence. But by the way, I will speak later as to how the medical doctor should document. Some in the past have documented it correctly, as a result of which the court was able to use it. So from 2001, we are in 2007. Then in 2016, Afoloki and the State. Medical evidence was also used as corroboration. In that case, it was a 5-year-old young girl that was defiled. But the court also observed that sexual activities are rarely committed in public view, making eyewitness corroboration an unrealistic expectation. The mistake the prosecutors made in this case as well was the man was convicted and sentenced to, guess what? 5 years imprisonment with a fine of 300,000 naira. Now, what should the DPP have done? What could the DPP have done? The man has appealed. The DPP ought to have filed a cross appeal, challenging the sentence. But they didn't do that. So when it got to Supreme Court, they were livid. That why should someone commit such an offense, punishable by life, punishable with life, and you sentence him to a fine? So I will urge our DPPs, you must push back. What the DPP ought to have done in the prosecution ought to have done in Iko's case, they ought to have filed a respondent notice to say, yes, we agree with the judgment, but please, the court failed to consider this part of it. So there must be some form of pushback. I mentioned this morning, I also do EFCC cases. They are very aggressive. They push back every single thing. So every single mistake you make, EFCC will appeal it. And that's the reason why today we have 6 EFCC prosecutors who are senior advocates in the past 3 years. 6. Because there is the pushback, there is the energy. But some of our state prosecutors, DPP, they don't push back. And so if you don't push back, the court generally assumes anything I give the DPP, they will accept. And so if it's life imprisonment, I can give 5 years. The DPP goes out of the courtroom, makes a statement to the media. It doesn't read the judgment. You must read the judgment, identify every mistake, go on appeal to correct it so that you are setting a precedent. Then you're also helping yourself because you need it to become a senior advocate. So they made this mistake here, 300,000 naira fine. They went to Supreme Court, they upheld the judgment, but they couldn't disturb the sentence because nobody appealed it. Then there's one more. That's Boniface Adonike and the state. That one also medical, and medical practitioners should also know. The medical doctor in that case, that's why I highlighted it. Child has a waddling gait, sway in walking as a dog. The doctor described it in Exhibit A, the medical report. The court used it. That is it normal for a 13-year-old child to be walking like a dog? It's unnormal. It was used as corroborative evidence. So the doctors should document every single thing they observe. They do that well in Mirabel Center. They over-document. They do that well in Warif. They document them. And these are the expectations. What the SARCs should have is a template. And unfortunately, in the past cases of 2016, where we didn't have SARCs, they would just a one-sheet medical report. But now, minimum 3, Mirabel Center is 3 pages, Warif is 5 pages. They document every single thing. You are preparing for corroborative evidence. So the doctor's role is important. If you fail to document it, I was not there. How do I know what happened? But was working, and the Supreme Court recognized this point. So it's also important that I've said it demonstrates the court's increasingly nuanced understanding of various forms of corroboration. So while we recognize that medical evidence is corroboration, not only medical evidence, other things exist. I'll explain them. The jurisprudence establishes an essential distinction regarding corroboration requirement. And now, this is law. There is the general belief by practitioners that if the victim for sex offenses, there must be corroboration. It's not the case because the Supreme Court corrected what happened in Ikwo and the state in later decisions. It is only when a child gives evidence there must be corroboration under Section 209(3) of the Evidence Act. But corroboration is desirable, it's not compulsory. And this is what it says. Corroboration is compulsory where a child gives unsworn evidence. So the children are in 2 categories in the Evidence Act, those below 14 and those below 18. So those between 14 and 18, they give sworn evidence and they do not require corroboration. However, where a child is deemed competent to give sworn evidence, corroboration is merely desirable but not compulsory. Thank you. Now, there's another mistake, and that's the reason why we need to have specialized court. The trial judge must conduct preliminary inquiry to determine if a child is giving evidence, whether the child understands the nature and implication of oath, and whether the child can answer intelligently or understand the duty of speaking the truth. But mistakes are still being made. A child comes to court, the prosecutors in Lagos are well trained, that even if I don't, the first thing they say when they bring the child, my lord, this child is 10, 5, 6 years old. We urge the court to put the preliminary, they remind the court. And when I put the preliminary question, because we have verbatim recording, everything goes into the record. But there was a case, there was a mistake. Abiodun Oluwaseyi and Matthew. Abiodun Oluwaseyi, Matthew and the state. 2023 decision of the Court of Appeal. The court conducted preliminary inquiry, but the court did not write it down. This was what the Court of Appeal said. There is nothing on the record of appeal to show that where the lower court indicated the satisfaction that the child could rationally answer questions put to her and understand the details, telling the truth. So that case, the offender was discharged. So they have said the failure to record the plenary examination and the judge's satisfaction vitiated the entire proceedings. Now, technical law, some will say it's technical law, and that's the reason why we have special prosecutors. A prosecutor must know, so that we do not make the mistake, and the judges must know as well. The absence of DNA evidence, it creates a big problem. You don't have DNA. If you don't have DNA, should we let all the offenders go away? No, so we need to look for other support evidence. And so we have recognized medical evidence. We have recognized other forms of corroboration. I've said them here, and I'll list them. The first, Ogunbayo and the state. I cited the case before. That was why I used Supra. The victim's father gave evidence. Immediately, the man raped the 13-year-old girl. She ran to her father. She was holding her lower abdomen when she came from the crime scene. The Supreme Court said that was corroboration. The man didn't see the incident, but saw his daughter holding her lower abdomen. First, corroboration. Second, support evidence. The man is inside that room. The father ran into the room and saw the man naked. Another corroboration. Supreme Court said those were sufficient corroboration. He didn't see the sexual intercourse. Another corroboration is state Adonike. I cited the case before. The victim identified, the child victim identified the defendant. There was also circumstantial evidence as to how the child lured the victim, asked the victim to go and buy pure water, sake water, lured the 5-year-old into his place, and all of that. The court now used the word, what they call circumstantial evidence, as corroborative evidence. It was used. In Lucky and the state, the court considered the victim's immediate distress condition and traumatized state as corroboration. There are other forms of corroboration: bleeding, trauma. First responders, police officers, there's what they call, in Latin, is locus criminis, the crime scene. I've never received crime scene pictures from any IPO, and I've heard from over hundreds of IPOs, no single crime scene picture to say this is the crime scene. You'll see something on the floor. It's corroboration. Those who encounter this, but I received it from, guess this man in Abiodun Ibrahim, he was the victim's boyfriend. He repairs AC somewhere at Oyingbo. He couldn't even speak English. He was one that provided pictures to corroborate the evidence. The police did not. And so we have pictorial evidence, and now we all have smartphones. Clothing, I've never received. Torn underwear, I've never received. Video, yes. Pictorial evidence, I received it from this witness. When the incident happened in this Abiodun Ibrahim and state of Lagos, the victim had been a girlfriend to the offender for over 10 years. He even sent her to school. But she got pregnant for another man and started living with the new boyfriend. So he was jealous. So he went to the house, went with a friend, and that one knocked. And they knocked the door to see whether anybody was inside. So when they said nobody was in, she was home alone. Then they came again, rushed into the house. When the lady saw the former boyfriend, she ran into the bathroom. He smashed the door of the bathroom. She was breastfeeding. Her baby was on the floor. He started to press her breast in the bathroom. There were pictures of, they said it was breast milk on the floor, but the floor was stained. He broke glass to threaten her. This illiterate, the witness who didn't go to school, the new boyfriend, after they had gone to the police that night, they arrived at about 1 o'clock. He took pictures of every single thing and tendered them in court. And that was because, and the man's defense was consent. He said she was my former girlfriend, invited me over to her new boyfriend's house, and we had sex. And given the history, also given the fact that he was the one that sent her to school, who would the court believe? When this gentleman came to give evidence, if there was consent, why did you break glass? If there was consent, why did you break the door? If there was consent, why did you, even the pillow he used to support her back, he took the picture. All the pictures were Exhibit AP to P1 to P4. Exhibit AP was the certificate, P1 to P4 were the pictures he took. His evidence was compelling. In fact, this man lifted the court from the court, took all of us to the crime scene because we could visualize it. The pictures were clear. He said, this is the breast milk stain on the floor. He was describing it. But this man didn't go to school. Then we have people we have trained for many years. They don't do this. As a matter of fact, the defender was on bail because when I read the file, I didn't believe he did it. I said, boyfriend for over 10 years, sent her to school. I don't think this is possible. And there was a question as to who owned the baby. Was it the first boyfriend or the second boyfriend? So we thought the defense was blackmail. Oh, you didn't want to give me my child, and that's why you made this allegation. When I sentenced the defendant, he ran out of the dock, wanted to attack this new boyfriend in court before they restrained him and took him out of the court. That was the painful part of the evidence, corroboration. That's the reason why the courts are intelligent and wise enough to demand for this. Because sometimes you don't know who to believe. But when you have this sort of evidence, you have no doubt that indeed there was. Now, another form of corroboration. As I said earlier, we have a culture of begging. No matter how terrible you have done a thing, you usually will go and beg. When you go and beg, it's important we record the begging. This one of the trainings that I spoke with the DPOs. I said when they come to beg and say, Oga, withdraw the case. Say, Oga, write it out. That's what they do in EFCC. I'm not happy with this case. We want to settle. Write it down. You put it as part of your case file. It is corroboration. Oral admission is corroboration. Written admission is corroboration. Confessional statement is corroboration. R. and Francis Kofi, as far back as 1960, the accused confessed to the survivor's father. It was adequate corroboration because the man said he confessed to me, he did it. 1960, we used it again. Equal and the state, they missed it. Why should we have a jurisprudence, a case law of 1960, and the prosecutor failed to recognize it in 2001? It showed they were not reading. Then we have another Olawale Arogundade. Supreme Court have been consistent, where the Supreme Court now said it again. A confession may be oral or written. This was in 2009. Voluntary confession was accepted as core. In fact, in that case, there was a written confession which did not comply with the law. So the court rejected the written confession and used the oral confession as basis for corroboration. Okay, so I must have pressed something now. Just a minute. Can someone help me with this? So we always have a backup. We can continue. So where we're at it, so having held that corroboration may be written or oral, it is important for the prosecutors and investigators. He came to my house to beg. Two things. The witness can come and give the evidence in court. You need to prepare them. There's what they call, you don't tell the witnesses what to say, because the prosecutor is the prosecutor, not a prosecutor. But at least you explain to them, you get as much evidence as you can, and ask them to say it in their evidence in chief. And there's one thing I realized with this sort of oral confession. Defense counsel are always reluctant to cross-examine on that, because when they cross-examine on that, it will bring more evidence. So they keep quiet. And the law is clear. If you're unable, evidence elicited without challenge is good evidence. So the court can use such evidence. So I've said that the jurisprudential development of the court record, so the court already has all of this, and that's the reason why when the Supreme Court gives a decision or the Court of Appeal gives a decision, they are looking at all of us to say, didn't you people see this? We have so much avenue. Then you bring a case and it fails, then you blame the Supreme Court and say they are using technical law. These laws exist for the defendants who are presumed innocent. Indeed, some defendants have been brought to court and they didn't commit the crime. So we have all of these checklists. So I move to, which is the most important part. Now we understand. I said the prosecution burden extends beyond merely giving corroborative evidence. They must ensure they lay the proper foundation for a child to give evidence. As I said before, the prosecutors in my own court, a child comes to court, the first thing you say, my lord, this is a child weakness. We want the court to apply section 209 of the Evidence Act. They say it because I may forget. You must continue to urge the court to do the right thing. The dual requirement of proper preliminary examination and corroboration is a crucial safeguard in cases involving child weaknesses. The last part of my presentation is technology integration. Technology is so good that even if this screen did not come on, I would have continued here. Then if this goes bad, I'll continue on my phone. That's the benefit of technology. And we must use it. Effective prosecution of SGBV requires meticulous evidence gathering, proper documentation, and efficient case management. We have done our own part in Lagos. Lagos State Judiciary has embraced various technological solutions to enhance all criminal cases, including SGBV. It is for the investigators and prosecutors to do their own part. Even now, we have data analysts. All the data I'm giving here, it was our analyst that provided them to us. This morning, they still gave me an update. First is digital case management. Now, we started with our GIS in 2013, and it's a case management platform. I won't bore you with all the stories. It shows how cases were filed. As it relates to SGBV, this is what we have resolved. Data from GIS reveals significant trends. Now, if you have data, you can use it to score yourself. You can use it to know how you are performing, know areas of. In fact, the last data I shared in the Lagos Justice Summit, it shows that Alimosho area is the highest sex, where you have highest area for sex offenses because we have the data. But it's the data that only comes to court we have. Those ones that they settle at police station, we don't have. Now, it shows that we started GIS between 2018 when we set up the special sexual offenses court. Of the 2,128 cases filed during that period, 63% of the cases were initiated between 2018 and 2020. By November 2024, new SGBV case filings had notably decreased to 4%. So we can score ourselves. It demonstrates the effort Lagos State government is zero tolerance to SGBV and is yielding good results. I have the data here. You see that, I wish you could stay on one page. Okay, you see that 2018, we had 302. 2019, 2020, highest COVID-19 period, it was high, 577. By the way, and I repeat, it's important, it's cases that have been filed in court, not the ones handled in other, and the high court, not magistrate court. And you see where we are. From last year to November 2024, it has reduced. Now we can judge ourselves to say all these things we are doing. And we must also appreciate the media because when there's an acquittal, all the 80% that have been discharged, you don't get to read them in the newspapers. It's the one that has been convicted that you read. So everybody is afraid. So you can rob a woman, you can do whatever, but don't sexually assault that woman. And that's the message. And so the cases filed, in fact, there was a quarter, 100 cases were concluded. I received 140 new cases. But now, 5, 10, it has dropped to 91. It shows how it has moved, 63%, and now we are on about 4%. I repeat, it is cases that have come to the High Court. So maybe very soon our prosecutors will have no work to do because everybody is afraid to go to court for defilement. Most of them are even opting for plea bargain. I've also said that the e-filing in the magistrate court implemented through the Lagos, we have another e-filing system from the magistrate court. But the e-filing system is the DPP Lagos here. The e-filing system in the magistrate court is so sophisticated because I chaired the committee and I told them to put everything I wanted there. And they put them there. It creates a digital case file, and you won't believe it, the digital case file has, but they've not started because we are waiting to train the prosecutors. So we said we don't want to deprive police prosecutors the opportunity of filing cases in the magistrate court, and that was why they've not started. So they need training before they start. But when the police prosecutor wants to file a case, he can file it electronically in the magistrate court because that's the case, most of the cases will go first. The DPP is in copy of all cases filed by the magistrate. It's been designed like that. Then they have opportunity to scan and upload the extrajudicial statement. So those days where the DPP will have to write to the police to say, bring out the case file, then the police will bring the hard copy case file. We don't need the hard copy case file anymore because the moment the police files the charge, the DPP already has the proof of evidence, including the statement. If there are pictures of torn underwear, it would have taken it and uploaded. It's only the hard evidence, the real evidence, they now take to DPP. So this is a system in place that will ensure that every significant piece of evidence is documented. And by the way, the DPP in Lagos, they have the veto power. And so if the police files the charge, and the DPP feels it doesn't establish the element of the offense, they can terminate the charge. And so they have senior assistant directors in magistrate court that do the supervisory role. And that's the reason why we ensure that it was designed in such a way that the DPPs will have access to every single criminal charge filed in the magistrate court. Now, if we can't achieve that for all the categories of cases, can't we have a private meeting with the DPP and the gender section and say, let's even start with SGBV cases, do e-filing, and all the documents get to the DPP almost immediately? That is something we should, all the medical report that the DPP, the police receive, because sometimes, usually they do certified copies. They don't know where the originals are. And so all documents, including medical report, extrajudicial statement, photography, everything is uploaded in the system. The police don't have to bother about data. The data is managed by the system. And you don't even need internet. Once you file it, you can upload subsequently. It's been structured that way. And you can use the device. Magistrates were given the devices, and so when they started the e-filing, they were complaining that the systems were slow. Apparently, some of the magistrates went home, they gave their children, their children were uploading games. And so I told the consultant they should block it. So they blocked it in such a way that that system is useless, except for the purpose. So now, no complaints anymore. Because if you want to play game, Facebook will not open. Instagram will not open. And the data they give them, you can only use it for that purpose. Any other purpose, it won't work. Tech has been designed, you can manipulate tech the way you want it. And so now the magistrates are not complaining anymore. They are using it for the e-filing. So I want us to embrace this sort of system so that we can preserve evidence and not make the mistakes they made in the past. Then we have the LCIS. That also captures data for criminal court. But it's important that I know, because it wasn't part of the presentation before. I included it yesterday night. When I heard from someone yesterday that they are thinking of reducing the sentence for defilement under the VAP Act. You don't do that. I think they should come and take the data, and that's why when you have data, you can't doubt it because it's what we have. It shows that 63% of the cases in Lagos State, sex offenses, 63% are for children, defilement. So if 63, and this is the data, you have rape. Rape is 11%, because they know that women will fight back. But children, 63%. In some jurisdictions, they have proposed chemical castration. In some jurisdictions, they have proposed even the death penalty. So why do we want to reduce in Lagos, in Nigeria? So the penalty, in my view, should be severe, as a result of which, when you are discussing a plea bargain, they can come and say, okay, sorry, we did it. Okay, you want to help them, let them plead guilty to an attempt. An attempt in Lagos is 14 years. They will be registered as sex offenders. The end of justice is met. Then they will also undertake counseling. By the way, there was one conviction I gave, was the plea bargain, and the part of the plea bargain agreement was that the offender will undertake counseling in custody and must be issued a certificate after 1 year. You can structure it this way to show that, one, you've protected society, Then 2, you have also protected the offender so that it won't come as a repeat offender. So I do not think if defilement is serious, if it amounts to 63% of the cases, if the victim, and when I receive the case file, I look at it with one eye because I'm hoping to see 14, 15. But I keep seeing 5, 4, 3. And yet, the men that commit this crime, from the data, it shows that they are adults. Anyway, I'm about to round up. Evidence collection and management is also important. We do that. There's another system I told the consultant to develop on evidence collection. Now, there's a case of the Supreme Court that says a confessional statement must be video recorded. Police will say they don't have video recorders. There's a solution. Sim4red developed this recently. They've been on it for a couple of years. They had a breakthrough. I tried the sample in my court 2 weeks. I had over 15 witnesses for the 2 weeks. We had over several hours of proceedings. And guess what? At the end of the day, I received the transcript of each day's proceedings that same day. And what they've also done with the app is to tailor the language, because our intonation is not as good as the intonation of the Europeans. And so the intonation is tailored towards our own local intonation. So if I call Lagbaja or I call Oshodi, it picks it and it gets it correctly. So those that come to court and even speak pidgin English, they have it transcribed. And so what I told the consultant to do is to do a section for law enforcement agency. This is what it does. A man is giving a statement. I don't need to take him to a special room. I only take my tab. And the tab they are going to provide for the police will be specially made. They can't use it for anything. So when they take it to their children at home, it will be useless. And I'm recording him. As I'm recording him, the recording can be in 5 minutes. Then it's already saved on the system. It uploads. It comes in every single thing said. It comes in a transcribed form. That's not all. It also has video capacity and voice. This is the way it's going to work. If law enforcement agencies have this app, they can take confessional statement in compliance with the law, in compliance with the decision of the Supreme Court. When they are with this app, they want to do e-filing. Once they are filing, they transmit it to the DPP's office, all in electronic form. This is a game changer for law enforcement. And what I'm going to tell the Attorney General, who I've discussed with, is maybe we can't afford to do it for all of the police divisions. Let's use the SGBV divisions for a start, because that's the only case where without corroboration, you cannot get conviction. And if that is done, I believe we will have the required result in the fight against SGBV. It's also helpful. The same device we are going to use when you go to the crime scene. Just take pictures and take videos. It's as simple as ABC. And that was what they did in State of Lagos and Abiodun Ibrahim. I've said that the case demonstrates how technology enabled the preservation of crucial evidence. We don't have DNA. If there's no corroboration, defendant will go free. Financial crimes, I also preside over financial crimes. It's easy for them. A man steals 100 million, he buys the house. The person that sells the house, he pays into his account. If the person that sells the house collects the 100 million naira in cash, it's money laundering. If he pays into an account, the account has a trace. So for stealing and financial crimes, there is always paper trace. Sexual crimes, no eyewitness. So you must preserve the evidence at the earliest opportunity. Then I've also said there that we must integrate all of the systems together to make a formidable, robust ecosystem. So the IPO has this tab. It takes it to the crime scene. It uses it to take confessional statement. At the end of the day, it will use it to transmit to proof of evidence to the DPP. DPP has his own tab. They will use it when they will now want to come to court. They just put it in a flash drive and tender the flash drive in court. As simple as A, B, C. So I've said we should integrate the system, and I'll go to my conclusion. I don't want to bore you with the conclusion. I'll just give you bullet points of what we must do. Let's have this as our take-home. First, we must have specialized courts and specialized training. I think we agree on that. For states that don't have, the CJ can do it. It's just a letter. Just letters to all the different departments. Second, we must develop comprehensive protocol. We have a Lagos template, which I think in the course of this presentation, they will share with you. Systematic collection of evidence. Thirdly, they must prepare trial diligently. That is important, so that we do not have the mistake we had in Dankara's case, where the pretrial was not done. By the way, let me quickly say, in court, when a prosecution comes to present evidence, there's a section that calls opening statement. We have it in our rules, but because of time, we abandoned opening statement. They don't give opening statement anymore. Opening statement is to say, I'm charging Mr. A for rape. I'm going to call the victim who is going to say he raped her on this date. I'm going to call the medical expert who will say there was laceration in the hymen. I'm going to call, and that's what the prosecutor must say. So that way they tailor their cases, trial preparation. But because we don't have time, we abandon it. But I think we should go back to that. Let the prosecutor have a document as to everything in the case from beginning to the end. Then potential defense must also be there. So we must have this robust trial preparation. And the fourth point is we must use technology. We must have e-filing. Data is never lost. We have the e-copy, we have the hard copy. When we add the NSARs, we're able to download the files, and we're able to generate over 4,000 case files back. And so, notably, the scriber, which I've just described, the scriber, that's the one that transcribes. The scriber application by the police for real-time video recording and transcription of testimonies should be encouraged. It will ensure accurate recording and preservation of evidence. Let me give one example here. There was a man who came to court and said he didn't understand English. So the whole proceedings, I got interpreter Yoruba. When they played the video, it was with the DPO. It was frustrating. I watched it in court, and he was speaking in English. After that trial, the defendant's counsel opted for a plea bargain. Eventually, he was convicted for 14 years because they knew clearly, the video showed it. And this same man said he didn't understand English. Technology would bring out all of these issues. So these 4 points, if we forget anything, we must keep these 4 points in our pocket. And when we go back to our state, they say, what did you bring from Abuja? These are the 4 things we must take back home. I thank the organizers of this program for convening this meeting. I thank you all for your attention.
Okay, so we can have a standing ovation for my Lord Oshodi. Thank you very much. We're going to take few questions and comments, contributions at this point in time. Please, you may be seated. Again, like what we did yesterday, we'll just take few. Maybe I'll take one from here, and one from there. Okay, this is the part. Okay, because we've taken, I need a new face. Let me take from her in front, please. Thank you. Sorry, Mom, you spoke yesterday. Let me give a chance to someone else. Thank you.
Good morning, everyone.
Good morning. Your name, please, and...
I am Evelyn Ona, the Center Manager in Nuguta Masak.
Thank you.
Okay, my question is about the corroboration. In a case where the IPO, who is the first, the primary evidence personnel, and she refuses to come to court to give evidence, what should the prosecutor do to get the IPO to come to court to give evidence?
Okay. Before the response, I'll take one more question. Let's just take from her. The lady with the red outfit. Yes, please. Thank you.
Okay, thank you. My name is Dr. Ngozi Nana. I work for Heartland Alliance in Akwa Ibom State, and I'm the SARC coordinator. Thank you so very much, Honorable Justice Oshodi, for that beautiful presentation. Heartland Alliance has 5 one-stop shops in Lagos State, and then we work on health, gender, and justice. And then over the years, we have tried as much as possible to see how we can support and collaborate with what the Lagos State government is doing. Because in all the other of our one-stop shops in the other states, which are even here represented, our one-stop shops are commissioned as sexual assault referral centers. We are implementing USAID funded projects. So, but it's been so difficult, and I must applaud you and the entire Lagos State on what you do on gender-based violence, because I'm always reading up on the internet. I see your efforts. I see all the resources that is being recorded. And I am very, very happy about it. In fact, if there's one state that is doing so much as far as the issue of GBV is concerned, it is Lagos State. So, my concern actually is how those our one-stop shops can be commissioned. Like I said, we've been on this matter for so long, and I don't know why it is not happening.
Okay.
So I want to believe that meeting you here today, we'll be able to see how we can actually fast-track and make that a reality. Thank you.
Okay.
Thank you. Just to quickly comment on that, Justice Oshodi represents the Lagos State Judiciary. Your request and your concern is better taken up with the Lagos State Domestic and Sexual Violence Agency. You will contact the Lagos State Domestic and Sexual Violence Agency.
Excellent. Can we get a response from you before we go to...
Yes. IPO not attending court. It's a problem. Under the law, you issue a reproduction warrant. You issue a witness summons. After witness summons, you issue a bench warrant. I think we should take this to the head of the police, because the way police structure is designed, a police officer respects his superiors more than civilians, because we are civilians. Why don't we devise a means where, if you have a gender section, there's somebody who is going to manage the process, a superior police officer, so that if the DPP wants to issue the witness summons, don't call the police, issue it straight to his superior, and the superior will send it down. Some have argued that it may take time. I've issued witness summons, I've issued bench warrant against police officers, they won't come. There was a particular case I issued witness summons to the 2 IPUs, the one from gender, another one. They didn't come. The defense land called them, they came. They came to testify against their investigation. Yes. And, okay, unfortunate for him, there was other compelling evidence against the defendant, so he was convicted in that case. So, witness summons, the court will do. Bench warrant, the court will issue. But I'm issuing a bench warrant against the police officer. He's going to arrest the police officer. So, within the police structure and the DPP, I think we discussed this before, let them devise a very strong way. And if the police officer, for instance, is on transfer, I said this before in one of the conferences, every state should have a command where you have a center where they can give virtual hearings. So if the police is in Abuja, it should just go to the nearest command and go for the virtual. It doesn't have to travel to Lagos. And if the police is in Lagos and is in Badagry, you can go to the Festac area, F command in Festac, because it's a command, and go and do the virtual proceedings there. It doesn't have to travel to court. We have given all of these incentives, but yet we keep having results. So witness summons is the first thing the court will issue. Bench warrant is the second thing the court will issue. Then we need to prevail to the authority in the police to ensure that they attend court for these cases and develop a structure that will ensure that it's the superior that is giving the directive and not the DPP, because Excellent. They won't obey the DPP, they will rather obey their commissioners or, yes.
Thank you very much. Yes, please.
Thank you very much, Milord. Good morning, everybody. My name is Rita Ileva, Center Manager for SARC Ekiti. My question about corroboration. There are times that because of the high level of awareness in Ekiti, and because citizens want perpetrators to be held accountable and survivors to get justice, the amount of evidence that citizens bring to the SARC, especially with the aid of technology, although some of it we try to discourage, because they will even go as far as taking pictures of the vaginas of these children. What we usually notice is that even though the police is doing a lot, if they have interest in some of those cases, they will not transmit all of that evidence to the DPP. My deputy DPP is here. What I want to ask now, at times they will not even transmit the medical report. The DPP will have to come to the SARC to come and get, because we always have a duplicate copy. Whether as a judge, will it be a thing that the court will accept if some of this evidence we have that we collect ourselves to transmit it directly to the Ministry of Justice in a situation where police does not supply the Ministry of Justice those evidence.
Thank you very much. I'll take one more. Was there a hand at the very back before I move forward? No? Okay, so I'll take her. Thank you.
Thank you. I want to commend my Lord, Justice Oshodi, for your passion. You know, we've been talking about compromises, people trying to appeal, community leaders, church leaders, when there are cases of SGBV. And in Edo State, we have, sorry, I'm right, Honorable Mrs. Maria Mozeli Oligbe Edeko, Deputy Speaker, Edo State House of Assembly. We've tried to use the issue of compounding felony, to dissuade them to bring action against such persons that come, to plead that people that have committed these heinous crime should be pardoned. I want to know the rightness of our action. And again, the SARC Center, the Gender-Based Violence Center in Edo State, we have cases where survivors report cases to police stations, and they also report at the SARC Center. Now, the police officers we have at the SARC Center, they are posted to us from the divisional, from the area command. Yesterday, there was somebody spoke here that you can write to withdraw a case from a particular investigating station where you feel you are not likely to get justice, and go to another, police sector. Even when you gather evidence from there, you are taking it back to the state command. How does it work? Or can we totally go to the civil defense in cases like this if we feel that there is likely to be compromise? Thank you.
Jen, just one more, and that's the last, and you can take it.
My Lord, we're grateful for a brilliant presentation. I would also like to commend Lagos State for its excellence in nearly everything. Of particular interest, my name is Jane Frances Biani. I work with Legal Aid Council of Nigeria. I want to commend particularly this plea bargain approach to settlement of sexual offenses. Why? Because I understand about the reduced trauma, because the victims don't have to go through all of that, efficient justice, more convictions. However, there's also the problem of, lack of inadequate prosecution. You find out that there's lack of accountability. The whole hog is not carried along. That's the whole trial. So it's almost as if, we're not hearing everything that happened. Then the victim safety, if it's done so quickly, the victim is released back to society. And then there's also the problem of, my Lord has mentioned about inadequate investigation sometimes, which also mar good trial processes and all of that. While my Lord has also mentioned about the fact that, because I was really worried about reduced sentences being that, plea bargain as it is designed, you don't give them the whole punishment. But my Lord was able to say, okay, well, like for attempts, 14 years, that's commendable. But if the sexual offenses, what I'm trying to put across right now is that it should be encouraged, as in Lagos State, because if plea bargain is done, there will be more convictions. But then we have to be very careful about the reduced sentences as well, and how it affects the victim. So I want my Lord to look at how it affects the victim on that side, while the reduced sentences make sense, but let the reduced sentences be something like that, 14 years, 21, something not a slap on the
Okay.
wrist.
Thank
and
you
how
very
it also affects
Thank you.
the victim. Thank you.
Please go ahead.
So let me begin with the plea bargain. Now we have a plea bargain protocol which we use as judges. So the judge has discretion to reject it. But if I reject it, I have to send it back for retrial. I gave the figures. The cases are a lot. A plea bargain in EFCC, which I also do, special offenses, plea bargain is 98% of their cases because they have evidence. And so, in this case, we also have the plea bargain committee chaired by the Honorable Attorney General. The plea bargain committee, they have a yardstick for every plea bargain. If the offender pleads guilty before any witness testifies, it comes, I think what they'll be doing is 10 years. In fact, there was a young boy who had abducted a 19-year-old boy. He had abducted a 15-year-old girl and had sex with her. And for his own plea bargain, it was a lesser charge for 5 years, and he had to undergo counseling. I mean, I think, and they didn't conduct trial at all. It was at the earliest opportunity. If you look at the numbers, currently I have almost 600 to 700. A judge sits approximately 200 days in a year. So if I have to finish the 600 and I conclude a case in 1 day, how many years do I have? 3 years. A plea bargain, and it's not possible. You have approximately 12 months to 18 months to conclude one case. Now that you have social worker coming to give evidence, you also have, and in some cases, 9 months. So because of the volume, that's the reason why the Attorney General has deployed plea bargain. And so the sentences are in threefold. We have the one of 21 years, those that go after children. We have another category of 14 years, depending on the nature. Then we have 10 years, then we have 7 years, we have 5 years. It's at the discretion of the Honorable Attorney General based on the yardstick they have looked at. But regardless, if as a judge, I feel the plea bargain is not good enough, I will reject it and refer it for a retrial before another judge. That means the case will have to go through the full trial. Then under the Administration of Criminal Justice law, the victims also participate in the plea bargain. Some of them have lawyers. The OPD engage and speak for the victims. And now, they are including compensation clauses. I've sanctioned one plea bargain. It was 10 years, and there was 1 million compensation. So all of this make it attractive for people to embrace. So far, I must say, it has reduced the backlog. Secondly, and most importantly, there are some defendants that are genuinely remorseful.
Okay.
And all of that, a combination of that, we continue to say yes to plea bargain, and we have the discretion to reject it. Now, I will go to the Ministry of Justice. I mean, the question regarding who transmits the evidence. I think it's between the SARCs and the Ministry of Justice. So, now, every documentary evidence, they are always counterparts. The doctor has the original copy and gives the police another copy. The doctor can come to court and tender his copy. There's absolutely nothing wrong, because that interface is a pretrial interface. It has nothing to do with the court. So as long as you have the documents, they are in admissible form, and you can tender them, it's fine, you can tender it. So the doctor has his own copy, and the reason why we are promoting the e-filing and electronic copy is that the DP people will have electronic copy of everything. In EFCC, you know what they do? They just certify it at EFCC themselves, and they bring them to court to tender. I mean, it's a more organized structure. So for your case, if the police do not cooperate, and I think we had a very senior police officer who is going to speak later, there's that corroboration which you can reach out to them. But yes, the medical doctor can tender the medical report. He has prepared. And there's one thing you are forgetting. I mean, it's not an evidence. This is not an evidence class. Did you know that if the medical doctor testifies, he doesn't even need to tender the medical report? Yes. Because medical report is supplementary evidence. If the medical doctor testifies, he has given the evidence. So you don't even need the medical report. There are many cases that talk about it. You need the medical report. If the medical doctor one has traveled, is out of jurisdiction, then you need to now bring another medical doctor to tender the medical report. So yes, they keep tendering medical report, it's supplementary, but if a medical doctor gives evidence, that he has given evidence regarding what he saw, what he heard, what he observed is direct evidence, and the court can accept it. So that interface can be done with the prosecution, but the medical evidence can be tendered by the medical report. It's their own report. The last question regarding prosecuting for attempt, it has been part of our law. Attempt to pervert the course of justice is a misdemeanor, I think, starting with 2 years imprisonment. But people are forgetting it. Please, all we urge the police to do is when they come, they should write and you document it. EFCC prosecute a lot of people under this offense, trying to compromise a case. Yes, you can prosecute them. Yes, you can use it as evidence in the main trial. And also, most importantly, in Lagos, we have the DSVA law, which also criminalizes this. So there are so many avenues. So for people who interfere with the process, you are at liberty to prosecute them, and you can also use their evidence of compromise in the main trial as corroborative evidence, which is also a good one. Is that all your question? Yes, I think the police officer they explained it yesterday. If a case is reported in one division, it's always tidier to get them to withdraw it from the first division before they now take up. For instance, NSCDC is handling a case, and the same person goes to report to the police. You ask NSCDC, a withdrawal is simple, just a letter of withdrawal. Or amongst the inter-agents, there must be cooperation. You can write to the complainant will have to withdraw before moving to another division, which is a tidier approach. Because if they don't do that, you make it messy. 2 people investigating the same crime is waste of resources. Then, if the complainant does not withdraw, then the new agency investigating can write to the audit, say, we are now investigating this case. I've been involved in financial crimes, police is investigating, and there's a lot of cooperation at that level. Police is investigating a case. The moment the EFCC writes to them to say, we are now investigating, transmit the case file, within hours, the case file is transmitted. In addition, EFCC is investigating a case, but they cannot track. EFCC will write to the police to help them to track, and they will track and submit. So that at that level is working well. I've had so many cases where, so if it's working well for them at that level, then it must be able to work well at this level as well. So there must be interagency cooperation and collaboration to ensure that justice is served. I hope I've answered all the questions. Thank you. Yes, a pushback.
We're actually out of time. I'm not sure we can take any more questions now. We're completely out of time, but I'm hoping that you can
We'll do that off record.
Yes,
you can have that interface.
That would be great. Thank you very much.
Thank
Just a
you
round of
very
applause for my Lord Justice Oshodi. Thank you. Yes. Thank you. Round of applause for him. We're going to, let me just please quickly acknowledge the presence of, okay, what mic should I use? This one. Yes, I'd just like to quickly acknowledge the presence of the Honorable Commissioner of Women Affairs, Sokoto State, and that's Honorable Hadiza Ahmed. She here? Okay, she stepped out. Okay, thank you very much. We also have, for Cross River State as well, Honorable Irom Edema. Thank you, Shia. Thank you very much. We have the Permanent Secretary, Anambra State, Ministry of Health, Obiageli Uchebo, representing the Commission for Health as well. Is she here? Thank you. Thank you. I see you. Thank you. Also recognizing the presence of Mr. Felix Awaniyi. He's been here. He came, of course, yesterday as well. Deputy Director of Public Prosecution, Ekiti State. And we have DCP Rita MSM, the Deputy Commissioner, Gender Issues at the Nigerian Police Force. She's here as well. Thank you. Thank you. Last but not the least is Ogechukwu Bona Ibenegbu. She's the Assistant Director, Custodial Center, Decongestion, sorry about that, representative of the Director General of Legal Aid Council. Thank you. Yes, I see you. Thank you very much. Okay, so we are going to be going for a tea break, but before tea break, we need to take some pictures quickly right at the front, and I'd just like to invite some of our guests to come in to take the pictures. I'd like Laulu, please, Toyosi, Yewande, Uphiliat. If Irene is here, please, can I ask you to come forward? My Lord Oshedi, Mr. Felix as well, please. If you could come forward. DCP Rita as well, please. Can we get you to come forward? So we're going to take this first set of pictures with all of the Honorable Commissioners of Women Affairs here. Please, can I ask you to come forward? And the permanent secretaries as well. And the permanent secretaries representing the commissioners. Also for health, Ministry of Health as well. And so commissioners, Ministry of Health, Ministry of Women Affairs, permanent secretaries representing them. I'm going to step back. Let's just wait till we have everyone here before we start the pictures. Okay, so I'll step away. Is Toyosi here? Okay, so hold, please just hold. I'd ask all the SARCs managers to please climb up. SARCs, Anambra State, Borno, Ogun State, Edo State, Kaduna, Kano, Adamawa, FCT, Lagos, Akwa Ibom. Please, you could come up on the stage behind. Ekiti State, Rivers State, Cross River State, apologies, Bayelsa, Delta, Ebonyi, Enugu, Jigawa, Sokoto, Naja, and Yobe. Is it okay if they move back? You want them to step down? Okay, I'll do that. Yes, if you don't mind, please, this way. We can spread across this. This way as well. We can have more here, please. Okay, please, can I have someone assist me to move the podium down? I think that would help. Can I have someone take this? Thank you. Okay, you don't have to smile yet. I'll tell you when to. Yes. I will hear. Okay, please don't hold, please. I'm not sure we're ready yet. Okay, so begin the smile. Okay? Yes?
Thank you. Thank you very much. Okay, so the time is 2 minutes to 12. And we're going to have exactly 20 minutes for our tea break. We'll be back by 12:20. Please, I'll ask our honorable commissioners, permanent secretaries, to please go towards, right, okay, to go towards this, how do I even, the entrance, yes, to the holding room, for your tea break. Please, this way. Yes, we have Chidima. So Chidima is going to take you for your tea break. Please, the rest of us, towards my right. Let's have our tea break. We have exactly 20 minutes. So 20 minutes and we will be back here to reconvene. Thank you. Thank you. Thank you. We'll come back by 12:20. Please, let's go for our tea break. You can interact and network there as well.
Again, like yesterday, I'm sure we have sugar in our blood now. Yes, so there will be a bit of more energy. Please, if we're still at the tea break area, can I ask you to come in at this moment so that we can begin? It's exactly 12:33, and we need to continue. We have a whole lot to do today. So please, let's settle down. I can see some of us at the very back. Please come in as we continue the conference. Okay. So, allow me at this point in time to introduce again, she was here yesterday and responded to a whole lot of questions regarding the police. And I know that she's going to do excellently well today at this point in time. So I'm introducing, to take us through the coordination of the SGBV response across states. That sounded like a gunshot. I was like, what just happened? Okay. So coordination of SGBV response across state commands and police gender desk. We're having the Deputy Commissioner, Gender Issues, Nigeria Police Force Gender Unit, that's Force CID, Doctor, because she just got her doctorate degree in recent times, Dr. DCP Rita Oki, MSc. Please, a round of applause as she takes this session. And also remember as well that we will take comments and contributions right after. A round of applause for her. Thank you very much.
Good morning, ladies and gentlemen. I will take you down to the 36 states where gender desk officers are operating. But before then, I will just run down a little brief about gender unit. The Nigerian police has a high prevalence of SGBV with 30%, with 30% of women and girls experiencing sexual violence. The 2015 Violence Against Persons Prohibition Act, VAP, provides a legal framework for addressing SGBV. So the coordinating structure, we have the coordinating structure. At the national level, we have the Federal Ministry of Women Affairs and Social Development, coordinates SGBV responses nationally. While at the state level, each state has a Ministry of Women Affairs and Social Development or a similar agency responsible for coordinating SGBV responses. Local government areas, LGAs, have designated officers for SGB responses and coordination as well, where we have some key actors in this vice. The National Agency for Prohibition of Trafficking in Persons, NAPTIP, handles human trafficking and SGBV cases. Nigerian Police Force responds to SGBV cases and provides security for survivors. The Ministry of Health provides medical care and support services for SGBV survivors, while the civil society organizations offer counseling, legal aid, and advocacy services. In all this, there are actually challenges we face. In addition, we have insufficient resources that hinders SGBV cases, is a known fact. And actually, just like what I was saying yesterday, when cases are reported of this nature, we don't expect the meager monies the police get to pursue SGBV cases. So in most cases, we do that personally on our own to ensure that cases are being done naturally. So we also have a limited capacity, inadequate training and capacity building for respondents and officials, though we are working in coordination with our partners that did training for us one way or the other that we are benefiting from as well. We have the social, cultural barriers, stigma, cultural norms, and patriarchal attitudes hinder reporting such cases and responses. This is the very, very difficult one because of data collating. In terms of data collating, while we are in our own data space, collecting our data, we have other agencies. I know the Women Affairs Commission, they have their database. NAPTIP have their database. So, in fact, to coordinate all this one to be in one body is really, really difficult for us. But we'll get there someday. And let me come back to gender-based violence, SGBV in states. Normally, we have a platform, and that platform, my gender desk officers, they report cases to us. So when they report the cases, from there we give them directives on what to do. At times, they have difficulties. There are a lot of difficulties in the sense that when cases of that nature is being reported, in fact, I have one this morning before I'm coming here. The suspect, the boy that raped a 10-year-old girl is in my cell now. This morning I got to the office. The families of the survivor said she's no longer interested in the case. That's where she is staying. She's having a lot of backlash and she could not stay there, so therefore she wants to close the case. I said no. Whether you are interested or not, that case must continue. And the case has been approved and we are working on it, and the girl has been taken to hospital for examination, so that case will definitely continue. So we have serious cases in states like Lagos. Lagos, they have a lot of rape cases, SGBV cases in Lagos as well. But with the help of my Lord and the center in Lagos, I work with them too. When they have cases and they want to refer to me, and we work together in partnership. And they too, they are doing a very good job. At least Lagos is a model for us to emulate. And I think FCT and Abuja, we should learn from Lagos. We've gone to several trainings in Lagos with UNICEF on children in conflict with the law and children in contact with the law. So we had a lot of interaction there, and as it is, things are coming down gradually. But what are we talking about? SGBV is predominantly in the northwest, northeast, northwest, north, far north. Due to insurgency, we know that a lot of insurgencies, because of that, a lot of people they run into the wrong hands, and at the end of the day, they are being defiled. And apart from that, the Inspector General of Police wants to take it upon himself. We are bringing in the special persons, the persons with disability, so that we are looking into that aspect, as well as farmers. Because for you to go to farm, they rape you farm. So you can see it has spread so much. In as much as that, the Inspector General of Police has equally mandated the police training colleges to imbibe the SGBV cases as a caucus. So it starts right from the academy. And now there's also a mandate for universities, our universities, to have gender-based officers' decks in all universities. Because in that school space, there's equally gender SGBV in schools. We are all aware of that. In as much as that, the little data we are able to gather in our own space is from January to this current October, we've been able to get some cases across. So we have a total of 4,570 cases reported, while the total case under investigation is about 3,945, and convictions we've got so far, 409. And the total summary for now is that though the police, we have challenges, it's not what. Why I'm standing here, I'm expecting a lot of bombardment, but we'll get there. I know you have to ask a lot of questions about police, but there's no issues, no problem. Rome is not built in a day, so we'll be up to it. But I just want to pass something across. You know, just like I explained yesterday, the perception we have about gender, it is now a kind of phenomenon that has grown. So I think everybody's wary, everybody's kind of, you know, skeptical about gender now. You know, at the earlier time, when such things happen, you keep it. There is a case, I'll give you a case study. This one is most recently. The woman reported in a division. She came to first CID and made a report. Normally, when we have such cases in divisions, we call for the case files. So I spoke to the DPO and the IPO that handled the case. She explained everything. And I now said, okay, they brought this girl in, 3-year-old child, said the stepbrother defiled her, according to the mother. We went to the medical shows nothing. I called her, I said, come, what is the problem? She said because she wanted to get at the husband. She wanted the husband to remove that boy from their house. As it's your stepson. If somebody you have carried up from beginning till now, is it now you want to push the boy out? This boy is barely 15 years. So when I interviewed the boy, the way the boy was talking, very intelligent, I said, Mommy, I didn't do this thing. I didn't do it, but my stepmother refused to cook for me. She wants me out of the house. Do you know what? Guess what? She felt she did not get what she wanted in my command. She now went to report at NAPTIP. So you can see, when the table turns, at the end of the day, I tell people, I have my integrity to protect. When I tell somebody here, you see me standing here, I have 5 grandchildren and a great-grandson. That is me. So when it comes to children, I don't joke, I don't compromise. There's nothing like compromise when it comes to rape cases. No matter what, I'll go to the extent to ensure that justice is served. So in all these old issues, gender, to speak, is why it needs collective responsibility. All of us will come together so that we can now drop it to the barest minimum. Thank you very much.
Thank you. A round of applause for her. So, DC Rita, I'm thinking that you kept your presentation short because you know there are so many questions and comments that so we can
I know they will bombard me,
okay,
and I'm ready.
So thank you for that. That means that we're going to give more time towards Q&A because we have more time from her side. So based on this, am I going to start from here or there? Can we have the mics also being brought to the... Thank you. So can I take... No, she doesn't. There's a lady in front, please. Yes, I'll take her first. Thanks. You're not smiling.
Good afternoon, everybody. Well done, Ma.
Thank you.
I'm Sidikat Bello Adegboye from Salama SARC, Tudunwada, Kaduna. I have an issue at hand now. It's a case of rape, blatant rape, that we gave a medical report about. But I'm hearing from underground that the parents have gone to do some kind of affidavit in court that they are no longer interested in the matter. But I have refused to back down. The issue is, why is it that the danger unit will be admitting just frivolous affidavits in the clear case of rape and agreeing with the family of the survivor that the matter should be settled? It is not for the police to settle. Take the matter to court. If we didn't succeed in court, we know that it is the court that happened. The police should not be in a position to be siding for settlement of rape cases. Now I'm interested in going further to, I don't know how to go about it, this issue of liability of screening an offender. How do we go about it? Can we do anything as individuals? Or it is the same police that have to file for screening of an offender to punish the parents of the survivor? Who goes to court for that?
Okay. That is, let me answer them. That is unacceptable. Do you have my number? Okay, I'll give you my number, right? I'll give you my number. That is, just like I said a moment ago, rape is not a compoundable case. You don't compound it. I have a matter this morning, and I told them no. You know, in false CID, before a petition is approved, it follows processes. I have done that process. What is going to happen is I will take your number, I will talk to the gender desk in Kaduna, and incidentally, I started my police career in Kaduna. So I is Kakuri and Tuduwada.
DCP Rita, you gave your number out yesterday. So I'm thinking, do you want to give it?
No, I will give it to her.
Just specifically to her.
I've given that yesterday.
Okay. Okay, thank you.
Should I give the number out again?
Yes.
Okay, 080.
Thank you.
080-7722-8516. Please, I want to assure you, in your respective areas, if you have any difficulty, whether from the DPOs, the area commanders, or even the police handling your cases, you are not satisfied, please let me know, please. It's very important.
Thank you. She would call it at the end again. Yes, I'll make sure she does. Okay, let's go to the very end. Where's the mic? Yes, let's take that quickly. Yes, please.
Good afternoon, all.
Good afternoon.
Thank you, DC Rita, for the presentation. I want to commend you for the good work you are doing. In respect to collaboration.
Your name, please, sorry.
My name is Victoria Lad. I work with the Federal Ministry of Women Affairs.
Thank you.
The case of the child that was taken from the police to NAPTIC, and you didn't find out what is the outcome, because NAPTIC is not supposed to have received that case, knowing fully well that the police is handling it. Police is government, NAPTIC is government. And so NAPTIC is not supposed to handle that case again since it has been reported to the police. And so now that you know that the case was with NAPTIC, did you follow up?
Madam, can you be specific? I have a lot of cases. Can you be specific,
You
please?
mentioned a case. You mentioned a case during your presentation.
Okay, I can remember.
Yeah.
That case wasn't reported with the police. It was in NAPTIP. So what happened was NAPTIP released a child to the mother. And incidentally, the mother of that child wasn't residing in Nigeria. So to the grandparents. So according to the Women from Social Development Center, they said they got a call from your minister to release without documentation. So I think it is when the father of that boy was blowing hot, they came up with a petition. And indeed, that petition took us to Enugu. But by the time we got to Enugu, you know, this child is with the grandparents. We couldn't retrieve the child officially from them. So that was why the father had to repetition. Not that the case was reported. They, in fact, the two people in social development, I detained them, the two women. I had to detain them because they want to use police for cover. And I said no. So at the end of the day, I know you remember the case.
I remember that one you are saying now.
Yeah.
But the one you said during your
With the
presentation.
son and the stepson?
Yeah.
And the hymen, I know you mentioned, yes, there was a...
Which one is that, sorry?
It was in your presentation. You were talking about the boy and the step...
No. No, I think there's a confusion here.
Okay.
Because I know there is still another one whereby a little girl and a small brother, they were in, I think NAPTIC started that case. So after NAPTIC started the case again came back to the police. So we made efforts. I think that's the case you're talking about.
No, the case of the man, yes, stepson. The boy is a stepson to the woman. And they reported to the police. And while you were handling it, the lady now left you and went to NAPTIC. What I'm saying is that, did you follow up? Because you know we have a strong collaboration,
Yeah.
and since the case have gone to, left the police to NAPTIC, NAPTIC is not supposed to receive that case,
Yes,
knowing
yes.
fully well that the police is handling it.
Yes. What happened is, when the team leader, I think the team leader is here. The team leader is here. When the woman went to NAPTIP, we were only told that she's not coming back. So what the police needs to do, we need to write a memo to our police authorities to give us instructions from there. It is then the police, but based on our write-up, our memo, will now indicate that this case, the complainant now has gone to NAPTIP. So it is for the legal department to write to us and tell us to do the needful to probably write to NAPTIP. Are you clear? I'm working under an institution. I cannot take decisions on my own. I have a Deputy Inspector General on me. So for me to go directly, it will be inappropriate. So we need to follow the procedures. So when we've already written to legal, we are waiting to get legal's response. So immediately legal responds to us, then we can now forward to NAPTIP to inform them that that's the stage we are.
Okay.
Am I clear?
Thank you. Still the mic. Where's the mic? Let me, before I come forward, I will come forward. Please, can I take that gentleman with, no, not gentleman. Oh, sorry. The lady with green. Yes, thank you.
Thank you. Good morning, everyone. Inakeme Ojineme, League of Women Voters of Nigeria, FCT SGBV Response Team. Thank you, DSP Rita. Yesterday during your presentation... DCP, sorry, ma. Yesterday during your presentation, you talked about every Thursday you go out on advocacy.
Yeah.
And that's a good one, a proactive one, but I want to know how effective it has been within your police community and the community. Because it's just from your presentation I've heard about it. I've not really seen that advocacy. I don't know if it's here in the FCT or outside across the 36 states. Thank you.
You know, they say charity begins at home. We have to start here first. So what
do
we
you carry other agencies along, CSOs, or just the police alone?
For now, it's just the police, but you are welcome to join us. It's on Thursdays.
Okay, ma.
It's just the police alone. What we do is, on Thursday, we wear our SGBB t-shirts upon the jeans, and we go to marketplaces. We try to sensitize the women. We go to orphanages to tell them what SGBB is all about.
Thank you. Thank you very much. The gentleman with his hands raised, I will come forward.
Hello, good morning, everyone. My name is Onyali Gabriel. I work with NAPTIP and also the protection officer in Abuja Municipal Area Council.
Thank you.
This Imam, I want to find out, is there any directive from from IG that instruct the DPOs that if any case is reported within their jurisdiction, they should not allow that case to be taken by any other law enforcement agency?
No,
this is my experience. My experience in Karimo, Jukoi, Galadima divisions. In Karimo, 3 minors were defiled by an offender because we work with the community. The vigilante now reported the matter to NAPTIP. But because of logistics, we are making preparation to come to Karimo. But the perpetrator now tried to run away. The vigilante now arranged and arrested that offender and took him to the Karimo division for safekeep. And they told the DPO that this matter has been reported to NAPTIP. But because the perpetrator was about to run, and that's why they arrested and then brought him there for safekeep. Each time we go there to take up over that case, they only refused. The instruction is that there is a directive from IG that asks them that whenever a case that happens within their jurisdiction, they should not allow that case to go out. That is
was
one.
Expressly stated?
Yes. So, and the greatest surprise, the same community again called us later in the evening that they saw the perpetrator moving around the community. And they became afraid because now that the police allow him to move around with their life safe, because those minors, 3 minors, defiled 12 years, 10 years, and 9 years. And that's why, but in most cases, whenever police are handling a case, we don't interfere. NAPTIP doesn't interfere because we are the same agencies. The most important thing is to achieve results. But at the end of the day, community always report, whenever they report cases to police, they don't get results. And that's why they always want NAPTIP to handle that case. But each time we go there, police always don't allow that, don't release that suspect. Whenever the suspect is brought to their facility for safekeep, for NAPTIP to come and take over the case, they don't release it.
Okay, thank you very much.
Thank you. In the first place, that instruction or that directives is not to my notice. I don't know of that. And incidentally, we know each other. We'll be going to programs together. If such cases are being recorded by you, what you would have done is you should call me and call the DPO to order. There's no big deal there. Or, worst scenario, we will send a signal from our end to bring the case, then you can, the suspects, you can carry your suspects. Because we are the same agencies and we work pari passu, so there's no need to seize suspects from you. And it's very painful that after defiling 3 little teenagers, young children, the suspect is left aloof, which is not really too good.
Okay.
So I think I will take cognizance of that case, maybe after this section, so that I can find out from the DPO where is the extent of this case and where has it gone to. So that wherever the suspect is, they will provide the suspect for me.
Thank you. Yes, ma'am.
Thank you very much. My name is Mufuliat Pujabi. I work with Sustainable Gender Action Initiative. So, Madam DCP, I know you're trying and you're doing your best, but one of the purposes of us networking here is to create a good synergy, that would advance our general response to the issue of SGBV in Nigeria. During the first presentation by Honorable Justice Abdurrahman Oshodi, he mentioned that some cases were thrown out because of the way the cases have been presented by police IPOs. I would want you to please explain what's going on and what can be done to improve the process. Because if we have the few cases being reported not properly attended to, investigated, and justice gotten, then there is a huge problem that we need to respond to. And I also know that the police, I was part of that process, have a manual developed on sexual and gender-based violence, and quite a number of police officers have been trained. So how come we have police officers who have been trained on investigating a crime scene, taking evidence and all of that, and not bringing it forward? At least if we don't know about all across the country, we've seen that was presented to us this morning. And the example of somebody that is not even educated, someone who hasn't been into the 4 walls of the classroom, documenting evidence with just a phone. So why is the police not doing that?
Okay.
And I'm not trying to put you on the spot, ma'am. The IG, to what extent, the Inspector General of Police, to what extent does he know the extent of pains that police officers also go through in delivering on their assignment? Because working on the manual, I had the opportunity of visiting some police stations across the country. And I know that at times when cases of defilement, cases of rape are reported at the desks in the police stations, they are looking for money for transport. They are looking for money to document and all of that. These are real life instances. So to what extent does the IG, you are here today, is the IG getting the feedback of what we're saying at this conference? Because we cannot continue to say one thing over and over again. And if the IG cannot enable the police station to respond to something that is as criminal as SGBV, then we have no space talking about it. Because the police plays a central role here. Yes. If there's anything else that we need to do, we should do it. We should hold the IGP accountable. He should be able to respond to us as Nigerians.
Thank you.
Thank you.
I think just to get my Lord Oshodi to, I think he wants to add to that.
On the back of that question, how can you help us in other states to get the IPOs to come to court. Is there a template we can devise here so that everybody will go back to their state and tell them this is the template we must use? Because I think that you play a very strategic role in this. That's number one. Then secondly, so that when they go back to the different state, we can say, if IPO does not attend court, call this number. Or if I want to issue reproduction warrant, DPP, send it by email to this place. So that from your office, you give the directive and they will comply with it. A very workable template, because once there's a signal from your office, everybody will obey.
Yeah.
That's number one. Then secondly, there's
That's
a trend.
number 2.
A lot of confessions have been thrown out of the court because there was no video recording, which is one of the corroborative evidence we need. Do you have anything in place in all the SGBV divisions to show that they are now being recorded now in compliance with the law? Or secondly, if they cannot be recorded, can they reach out to the Legal Aid Service, Council of Nigeria, so that they have their lawyer present? Thirdly, if their lawyer is not present, what EFCC will do, they will allow the suspect to write a statement to say, I have been informed of my right to have a counsel. I choose to write my statement on my own. Can it be imprinted on your extrajudicial statement?
Okay.
So
Statement
that they
form.
just, in statement form, so that they can sign it. I think that requires immediate attention. One, video recording. Two, do you have lawyers on standby? I think Legal Aid Council of Nigeria is there to say, before we take your confession, you don't have a lawyer, let's reach out to Legal Aid Council of Nigeria to support you. If that is absent, then do they have a statement from the endorsement on the, I know the cautionary word is there. EFCC, they have now incorporated that I have a right to have my lawyer present, is not around, I still want to go ahead and write my, so that this statement will not be thrown out in court.
Yeah.
Thank you. That requires immediate action.
Yes, sir. You're very correct, sir.
Okay.
Thank you, sir.
So maybe give a response before we go to...
Okay, so, madam, you know, when it comes to investigation, let us take the states, for instance. Some of the states are in the capital, and there are some outside the divisions. So since it's like that, at times, when the cases comes like this, the DPO can use his discretion instead of giving to gender desk officer to maybe DCP, crime. And when it gets to crime department, they mess it up. They mess it up. So at that stage, that is why I still stand. So long as it's SGBV, so long as it's maybe defilement or whatever offenses that has to do with children and women, what the division does should first of all get across to me. That's what we do. We interact. If they have any difficulty, they tell me, I give them instructions on what to do. And in the case of our IPOs not being, because it's really so sad, after putting more effort and everything, at the end of the day, they throw your case out. I have a case that is still pending now, unfortunately from Urumi. The father of this girl, they are both in the US. The mother and the father, they are in the US. I know US children, the way they behave, they overgrow more than their age. So I think the father decided to bring her back home. So the father called me and said, my daughter is missing. I started making calls because incidentally, I was area commander Auchi. So that was how he knew me when I was in Auchi. So when he called me, I said, no, I'm in Abuja now. So he said, my daughter. So I called the area commander Auchi. When I was there, he's still there. I said, please look into this matter. Quick. We are looking for this girl. After all said and done, both text messages, all the discussions the girl had with this boy indicates love affair. But that is not the case. How did this girl leave the boarding house to follow this boy out and slept overnight and came back to the school? I had to go to Uromi to bring the principal, the house mistress, the maid, all those that are involved for the well-being of this guy to Abuja. So when everybody came, they made their own submission. At the end of the day, when it happened there, quickly they went to a private hospital without the police. They went to a private hospital and did the medical report. And I requested, bring my victim. Let me hear from her at least. Even if I know she's a young girl, she's about 15. Let me talk to her to get at least some information from her. The father said no. The father said no. Before I knew it, this girl, she's back in the US. I don't know. I thank God my Lord is here. So what do? There is nowhere this man has not dragged me to. So I now said, even if they have done medical there, this is Abuja, I will do my own medical so that I can get my own impression on what happened. And I should be able, I even pleaded with him. I said, can I have a video talk with your daughter, even in the US? He refused. And the petition he petitioned me now was that I didn't want to carry out his bidding. And I said, I want the person, even if I go to court, I don't want to go to court and fail. I cannot fail. I will tell you the truth. You are a friend. I will tell you the bitter truth. Because there are certain things I need to know. Up to this moment, we've sent report to legal for advice. Okay. When that one comes out, we cannot take it up from there. So at times there are cases like this that, you know, at times your hands are tied. There's nothing you can do. Even if I decide to say, okay, this case must go to court, I must push it to court. If it gets there, it will not see the light of day. Because if they have a very sound lawyer, if they have a very good criminal, they will just knock me out. And that is what I don't want. So, you know, this thing cut across board, madam. We will improve on our IPOs to ensure that our cases sees the light of day.
Thank you.
They will see the light of day. I promise you that.
And
thank you so much.
Recommendations from my Lord Oshode. Do you want to say anything on the templates?
Yes. I think we'll work on that, sir.
Okay.
I think it's very important. It's very, very important.
Thank you. Please
yes,
go
sir.
ahead.
We'll work on that. After now, we'll talk on that one.
DCP, Dr. Rita, thank you for the wonderful presentation.
Thank you.
Mine is more of, will I say, comment and a question. And the question is, how often do you train these IPOs? How often?
Gender desk officers?
Yes, how often do you train them? And the second, my recommendation is that, because, well, I didn't introduce myself. I'm the Chief Executive Abia State Hospital Management Board. Okay. And primarily, I'm a pediatrician. So countless times I've actually met patients who have been sexually abused by their own fathers, as young as 2 years,
3 years,
5 years. And you want to help them. And you'll be shocked that the person that will even stop you will be the IPO? IPO, yes. They will not even believe the story. I remember a particular woman, the IPO, told her, Madam, you're possessed. How can you accuse your husband of such? So my question is, what kind of training do you give them? How regularly do you train them? Because I believe that repetition brings attention. You don't train someone one-off, and you don't monitor their proceedings, their process, to be able to know that these things is being stepped down to the where those who are assaulted will benefit, because they are a major problem in investigation of these cases.
Okay, thank you.
They so frustrate the people who are involved that they give up even before the matter goes to court. So you need to do a whole lot of work and to really emphasize on those training, because trainings is not something you do one-off. It has to be regularly.
Okay.
Thank you.
Can you just pass the mic to the... Okay.
Thank you so much. As I speak to you, from 25th to we have 5 days training for all gender desk officers across the country, including their personnel. They are coming to Abuja for training. Then next month, we are taking them zone by zone. Like now, what we are doing now in our gender lab, we have a gender lab in the 4th CID, which we are trying to upgrade. We want a situation whereby the 6th geopolitical region will be captured, so that I'm seeing them as they are reporting cases. We are seeing the cases and we are responding to the cases. So that training you are talking about is what we've been doing with other international partners. We have training for this month. We have training for early December. So it's a continuous exercise. You know, it's a very large organization. There are some people that their ear is on the ground, but we need to pick up that ears from the ground and stamp it back at their head.
Excellent.
So it's
Thank you.
normal. We are going to do that. Thank you.
Thank you so much. Thank you so much, Ma. My name is Grace Johanna Abin from Sexual Assault Referral Center, Kafanchan, Kaduna State. We have concern for our survivors because they are the reason why we are into this. And for the best interest of our survivors, we realize that we have cases from Kafanchan. They will insist the survivor will have to pay the bills for transportation all the way from Kafanchan to Kaduna. You can imagine somebody whose daughter is being raped. The person is asked to pay the bill because they don't have the money, and investigation is being intercepted along the line, so that some evidence are even missing even before they get to Kaduna. At the end of the day, the survivors will back out and tell you they don't longer want the cases managed. And it's not just one more movement, it could be to and fro continuously, and the survivor will be asked to pay this bill. How do we break the culture of silence with this? How do we make people speak up with this? How do we get justice for our survivor with this? This is a problem. And one other one, our survivors get intimidated. If you open up, if you speak, do you know where we are taking this case to? You are going to pay this bill. You are going to do this. You are going to be shamed. And they keep intimidating them, and they feel they don't want to speak up. That is a problem for us. I don't know how you will help us in this area.
Madam, thank you so much. That is why I gave you my number. They cannot be above me. They are all under me. There are people you give directives to and they take it. Do you understand?
Yes, ma'am.
I will still tell you. A 15-year-old boy is almost teenager, that the father have not set eyes on him for almost 8 years. My team now, they're in Kazaure, in Jigawa, prevented all efforts to recover that boy, proves abortive. We had to go to extra measure by using our armed mobile men to bring that boy out, because the grandfather insisted on seizing the child from the real father. So there are a lot of cases, but the only issue now is, when it comes to that, you have my number, call me.
Thank
Whoever the police is, this issue I'm telling you, I spoke. I didn't need to go. I spoke to the area commander. The area commander traveled from Jigawa to Abuja. You understand? So it's just communication. So there's no problem. I don't think a gender desk officer, as at now, will demean a victim. I think that era is long gone.
Okay, thank you.
If you have that kind of issue, please let me know, please.
So can we specifically hear this from the SARCs managers? Are you all confirming what she's saying? And it's not in the past, it's still in the very...
Do that still do it? Please report to me. Report that IPO to me. No, there's no... everybody cannot be 100%. If they still do it, please let me know. Let me know. Get me involved. I will walk you all the way down.
Sorry, since
Please.
she asked the question and she's speaking on behalf of the... Yes, go ahead.
Please, for security reasons, I wouldn't want to pick it alone. I would have loved a situation where you pick it like a holistic issue and address it so that I don't get attacked myself.
Okay.
Because if I have to report directly, I'll be in trouble.
No, you won't be in trouble.
No. I know the security situation. So it's good we handle it holistically, because this thing I'm talking about, last week, a family whose child was raped have to pay the bills down to Kaduna. And it was inconveniencing. Every time I keep having call, what do we do, where the police is investigating? So I'm exposed to danger myself. So I think we have to handle that holistically.
No problem.
So that they know it's a system,
we'll
not
take
a personal
cognizance
issue.
of that. We'll take
Thank you so
cognizance.
much.
But you should remember one thing, madam. When, it's what we've been saying here. When it is funding, police, gender unit does not have anything that has to do with funding. We don't know. And you can imagine these people, if they say they are moving from point A to point B, it's on their own accord. Because who reports a case? He who alleges must prove. You have to prove your case. So when you are alleging, I don't see any reason why they will go and meet complainant that is already bruised, that is already abused, to go and bring money. That one is not straight. Please, let me know. I will take cognizance of that.
Please go ahead. You could go ahead.
Yes, ma. In addition, ma, I'm CSP Rosemary. I'm a gender desk officer. Ma, please, in connection with your question, I want to ask, there are general IPOs and there are gender desk officers. Okay. So I want to know, ma, is it a gender desk officer or a general IPO? Because we are two different people.
I see.
We have been trained to take care of these survivors.
Okay.
So if it is a general IPO, we might not have the knowledge we had. Please,
can I get a general concessions response
yes,
from
you might not know. So when you get to
managers,
police station,
sorry.
ask for a gender desk
unit.
officer. That would be better, yes.
Okay, so can we, from all of our managers,
And madam,
are you receiving...
I'm coming.
Okay.
Madam, we have gender desk officers across the 36 states. I know your gender desk officer one-on-one because I was in the training there. So when it comes to gender issues, please, it's not being you involved because we are taking care of somebody that has been bruised. Reach out to me. Just tell me, madam, this is what I'm going through. I know how to go about it. Please.
Okay, so our managers, please, so that we're getting this feedback right. Our managers, are you reaching out to the gender IPOs? You are reaching out to the gender IPOs. Hold on.
Hello. I've given most of you now this morning, Please, if you have any of that cases that you know it bites down very well, please reach out to me. I beg you.
Most times,
because we need to save lives.
Most times, whatever the general IPOs are doing, some of the gender officers, they are aware. They know what is going on. They know what they are doing. Because I had a case recently. The victim, the survivor came to meet me to tell me they want me. The police officers are telling me to give them money to go to the crime scene to go and do the investigation, and then they also need money to file the papers and then take the papers to court. And then when she came, she gave me a total of this amount she had paid. I called the gender officer, and then the gender officer went ahead to call one of the IPO that was actually in charge. And the response I got later on was, the police cannot actually use their money. What will they do? That means it's true. They are aware of what is going on.
I stand to disagree with you.
Okay.
I stand to disagree with you. Can I say something? Hello?
Oh.
Hello?
Let's hear from you.
Hello?
Please go ahead.
You see, like my office is more or less a humanitarian job I do. Maybe because I'm the head. Do you understand? I can go out of my way and maneuver and ensure that my case sees the light of day. Do you understand? But look at these people. Sometimes salaries have not been paid. Sometimes it's in a darker situation. And like what I do in most cases, the victims, I keep them aside. And the perpetrators, whoever is coming for the perpetrators, those are the people I nab to carry out some activities. It's not really like that, because if you go now, a policeman, how much is a policeman earning for crying out loud? It's the same funding we are talking about. It's not the policeman's fault. The policeman has to do his job.
Okay.
Agreed, but it's not his fault. Let us be realistic here.
Okay.
Let's be realistic.
So, the purpose of why we're here, I can see it happening right now. And let me just try to clarify something. Dispirita, we hear you completely. We hear that if there's anything happening in the states within, all of the issues that they're raising, they can call you
me.
And you
I
get it
call
sorted
me.
out. But we're hearing something else. We're also hearing that this is beyond the calls, right? Is that what you're saying? So they are talking about being provided with funding, right? So let me get a man's perspective. She's supposed to speak, but since we're still on this matter, your question is completely different, right? So that I'll come back to you. I will.
Thank you very much. Okay. My name is Damola Lakute from Ogun State.
Yes,
on this issue.
Are you a SARCs manager?
Yes.
Okay, thank you.
Now on this issue, the reason why you hear a lot of us saying no to calling you is because there has to be a structure. What if you are moved? We pray that you will be promoted and all that. We can't keep calling you.
Yeah.
You can't manage the complaints we have all alone. That's the truth. You will get to a certain stage, you will be overwhelmed. So what we want to suggest, let us have a directory of all the gender unit officers.
Okay.
Now, when we have that directory, we can train them by ourselves in our states. Then we know that the police officers have problems with funding. We can also begin to shout that let the police authorities make provisions for this thing in their budget. Because it is a major problem. When we have cases, we first start from investigation. In fact, not just from investigation. We have to go and do rescue first as a SARC. We start from rescue. When we leave the rescue, we pay for investigation. It's so bad that we also pay for the feeding of the accused persons. When they are in custody, we pay for their feeding. Imagine the survivors do not have SARCs or any NGOs defending them. And when we finish, we also pay to get the cases filed in court. It's exhausting. I was telling my colleague this morning that assuming we spend 100,000 on taking care of a survivor, that is our primary objective. We spend over 400,000 on other objectives that are not ours. How sustainable is it?
Thank you.
Let us have a directory of all the gender officers.
Do we all agree to this?
Let us work.
Okay. That for the last speaker, you've spoken well. We can do that. We can still add by way of saying, police, we deal with signals. You just don't talk with your mouth. We deal with signals. So what I will do on this issue, I will put up a signal through the Inspector General of Police to all gender desk officers, so that by the time they relate to you with their phone numbers and everything, so that if you are not satisfied, if at that point in time you can get to me, no problems. But definitely it will be done.
Okay. Hello.
And I won't give you.
No. Hello, please. Madam, well done for your efforts.
Yes,
That's cool. I'm the Honorable Commissioner, Ministry for Women Affairs, Kebbi State. I want to share with you the way we are dealing with all this issue of lack of funding, especially as it relates to survivors. Recently, from my ministry, we wrote to the state government requesting for an imprest for the SARC center and a vehicle too, which were granted. So our SARC center now has an imprest of a certain amount of money monthly that they use to feed the survivors, to bring them forth to the center, and even transport them back to their places when they are discharged from the SARC center. And it's making a lot of difference in the way they were being treated, because we get more and more and more of them of recent. Thank you.
So I think your state should be able to help, just like Madam. Your state should help. It's gender issue. I want to use this medium to explain to you people that what happened to those children, those detained children, it's really unfortunate. And it's an oversight by the police, actually. And the IG called me and was asking me, do we have a center for children? I said no, because we can only deal children that are in conflict and contact with the law. Is not part of us. It's just that actually there should have been a place where those children are being kept instead of putting them in the main prison, which was not really right. And I think that issue have passed, because he called me and was telling him we have family court for children at that age. It's family court that cannot deal with them. But being that is me, at times ignorance of the law is no excuse though. But at times when things happen that way, we learn from experiences.
Okay.
Thank
you very much. I will come to you, ma'am. I see you. I promise you. But we need to get a response.
All right.
On this.
Thank you so much. Good afternoon, everyone. My name is Juliet Olumiwa Rufai. When it comes to center management, sexual assault referral center management, Nigerian's first sexual assault referral center manager. So all the managers here are supposed to pay me royalty. Anyway, I appreciate the work you're doing. And at the moment, I am consulting for ROLAC. on SARC establishment and quality assurance on operational effectiveness of SARCs. So we appreciate you. Police is our friend, right? And getting this feedback from all of us, because it cuts across. I visit almost all the SARCs. It's a real-time issue. And because we encourage our survivors to go to police stations to report, they come back to us with this feedback. And that's why you're getting this reaction. It's not like we want to attack you. We really appreciate you. And you have also mentioned a critical issue, funding, which you also appreciate. And the former speakers, even yesterday and today, they have mentioned and drawn our attention to the practice in Lagos, working with the Lagos State Domestic and Sexual Violence Agency. I think they have an arrangement in place now to support the police, but it has to be worked out in a particular way. So there should be a protocol. So probably you can also look at that direction to learn from them. Secondly, I want us to do things and take lessons home that are really very practical. Bringing out your number is good, but I'm checking within myself the practicality of everyone calling you at the same time or reaching out to you. Alone as SARCs, the volume of calls that we receive, we know how we handle them and how demanding and taxing they can be, let alone when all the SARCs are calling you. And on platforms that respond to SGBV, it is the same issue. So while we are looking at the area of funding, and we know that tomorrow position can change, even the gender desk officers, the OCs and all that, we know them. In Lagos, we have the family support unit and all that. And they have been trained and we engage them. Bema is the same issue. Even after they have gone for the training, some of them still do the same thing and give us the same headache. Therefore, it's not just the training, it's not just the funding, it is also a question of accountability. So that brings me to my request. How can you have a protocol and make sure that you follow through this protocol to hold police officers accountable? This issue cut across the 36 states in Nigeria, including the FCT. What the police they are doing in Kaduna is the same thing they are doing in Ekiti and everywhere. So it shows that there is a problem. In terms of dissuading survivors from accessing justice, in terms of using different kinds of words on them and their parents, and different kind of things that some of them you might not even want to talk about. You'll be wondering that, can an officer do this? So it's not just bringing them for training, which I know is very key. Let the Nigerian police force and even your bosses that you report to, let them have this feeling, feedback, and develop a protocol. My sister Mufilat here has said it. There is one protocol that go back to them, see how you can adapt them. And more importantly, we want to hear that an IPO that compromised or messed up a case has been held responsible. At least that will serve as a scapegoat. Thank you so much.
Yeah, thank you very much.
Thank you very much.
You have spoken well. In actual truth, personally, when officers are being compromised, there's something I really don't like. When I work with people, I don't fancy complainants complaining to me about my IPOs. I'm really, really not happy about that. Which means there's something they've seen in you. Either you are taking sides or you are trying to compromise issues. Like in most cases, what I do, once I observe that kind of thing, I don't leave you with my department. I transfer you out of my section. Fine. If it is very serious offense you have committed, the orderly room is there to take care of you. Because we have our structure in dealing with officers. It's not that it's a personal thing. Administratively, if you have erred, you'll be held accountable. And there are some of them that are like that. But it depends on, we are talking of a larger structure here. If I, on my own part, I'm trying to manage my own, what about the area commanders? What about the state CPs? What about the divisional police officers? So it all boils to accountability.
So that is why I urge very, very, very serious issues that you know is really getting out of hand. I don't mean all issues that has to do with gender desk officers. Or if you know any police officer is compromising, you can also, while we are here, we can create a forum whereby I can be talking to you on WhatsApp and where would still help us because it will still guide us one way or the other. But your feedback has been taken.
Thank
and
you.
I will take it up with the appropriate authorities.
Thank you. We
Thank
have
you.
a question here. Thank you.
Good afternoon, everyone. Thank you very much for this wonderful presentation and responses to our questions. My name is Fatima Mustafa Mohammed, Borno State Center Manager. My question is that sometimes survivors' parents used to come back to center and telling us that the perpetrators were released and coming back to treat them in the community. I called the attention of NAFTIP, and once I called the attention of police headquarters that the perpetrators are coming back to treat survivors' parents. They told me that they were being released on bail. That's why we are appealing. If they are being released on bail, please help us to brainwash or sensitize them that they are not released to go and threaten the survivors, because many of them used to come back and say that they have been treated by the perpetrators. When they are being released, they will come back and say that we have did this, that, and we are now free. We give money, or we did something, or we have money, or we have power, that we are already being released, and we will do it again. This is what they normally used to come and tell the survivors' parents. Thank you.
Yeah, in the first place, thank you, the last speaker. In the first place, bail is not, rape is not a bailable offense. You don't release bail suspects. I gave an example this morning, the case I'm handling, that the mother said he doesn't want the case to go further, that he wants to withdraw the case. I told her categorically that you are free to go and stay in your house, but when I need you, I will come and get you. But you see this boy here, the moment I release this boy, he's a 10-year-old girl that he has raped. He can go and rape for 3 years. I cannot allow that suspect to go. So there are people, it depends. But you know, human beings, they differ the way they take instructions. But I think it's a good feedback. In that wise, I'll put up a memo to the IG, through my DIG, that all rape cases on no account should be granted bail, so that at least you can carry it up from there. So I don't see any reason why they will grant a rape suspect bail. Well, based on what? So please, Madam, we'll take care of that. It's a feedback, eh? Thank you.
Okay, so unfortunately...
And I won't kill you.
Unfortunately, I'm sorry, as I'm speaking right now, I'm closing my eyes. I'm not even looking at anyone. Unfortunately, I have been instructed, because of time, I can only take one more question, so that just one more question or contribution. And this is how we're going to do it, please. If it's a question that we have already addressed and you already have the answer to, please don't raise your hand, right? And this person has to be a man, because we've taken several questions. This is Men's Day. So it would have to be a man, right? So which man am I taking? Wait, no, I haven't decided yet. Either him or him. So who's going to decide?
You can let the two of them now.
Okay, let's go ahead with you.
Okay, my name is, I'm Dr. Ango Francis Uchenna. I'm a forensic trained examiner from Abia State. I think we have identified a few things that are systemic. It has been mentioned. Mine is just to make a suggestion. We have the issue of funding, which is very basic, very, very important. The issue of accountability and training. These things have been mentioned. I want to request, arising from this conference, if there's a way you can help us and the organizers of this conference to take this thing further, maybe in the form of advocacy to the Inspector General of Police, to suggest to him ways he can help to at least reduce the menace of sexual-based, gender-based violence in Nigeria. And maybe if there is a way, maybe foreign organizations or even in the budget, Nigerian budgets, police budgets, ways they can include funding in their budgets. But I think that ROLAC and other agencies that are very, very passionate about sexual and gender-based violence can be part of this delegation, to advocate on how police can be trained. And if it is also possible, you mentioned about the trainings you have this month and next month. If a ROLAC can also help come in the training of these people and just trying to reorientate them and make them understand the need to ensure that justice is served at any point in time, so that funding will not be
a problem.
Will not be a problem.
Thank you.
Thank you so much.
Final words?
As soon as this program ends, putting up a memo, all your feedbacks you take home, I'll reduce it to a memo to the IGP himself directly, and probably suggestions on the way forward when it comes to handling of SGBV. And surprisingly, he's so passionate about gender cases, because he was my DIG before he was promoted to the rank of IGP. So he's very passionate. We do cases together. I walk to him and talk to him one-on-one, but I will reduce all what we've said here so that he can be able to respond to it. And I will still appreciate a situation whereby some of us, maybe if I know most of you have my numbers, we can pay a courtesy advocacy call to him. I can make that arrangement. Let it happen so that I want it to come directly from my people.
Excellent.
So that he will be able to, do justice to it. Thank you very much.
A round of applause for her. Thank you. Well done. Wow. Thank you. Let's keep it going. Okay. So this was a very interesting session, and I'm very happy with the engagement. I'm happy with the interaction, with the suggestions, the recommendations, and also the feedback she's given as well as to taking all your complaints back to the IG. Okay, so we need to move swiftly to the next phase of this conference, and I will be inviting the Deputy Director of Public Prosecutions from Ekiti State Ministry of Justice, that is Mr. Felix O. Awoni, to take us through proven sexual violation lessons from prosecutions of SGBV cases in Ekiti State. A round of applause for him as he comes to the stage. Thank you.
Good afternoon, ladies and gentlemen. The topic given to me is proving sexual violation, lessons from prosecution of SGBV cases in Ekiti State. I want to remark that the bombardment received by Madam DCP shows how central police institution is to our essence of being here. And I want to equally remark that I admire the way our women came out clearly to at least address the issue, and the responses we got from this side when she was here. The whole essence of our gathering here is to see how the meanings of of violence against women and girl child can be contained in our society. I must give kudos to her for what he has done so far. But at least in my presentation, there is no way I will not still speak about your institution. Why? Because investigation is very central to successful prosecution of cases. They are like Siamese twins which cannot be divulged. Whenever a case is slated for prosecution in court, what prosecutor is expected to do first is to ascertain what are the ingredients of the offense given. It is after you have ascertained this that you look at the list of witnesses before the court. Who is going to prove these ingredients among the listed witnesses? What am I going to prove by the other witnesses listed? And the standard in prosecution is very tasking because it has been stipulated that the prosecution should be beyond reasonable doubt. Whenever there is an iota of doubt, it will be resolved in favor of the defendant. That is the standard laid down by the law. And we cannot say because the allegation is gender-based, there is going to be a kind of shift from what will be held to during prosecution. No, the standard must be maintained throughout. So there are a series of lessons we have learned from our end at Ekiti State. And that is why I said I will still dwell much on investigation. Investigation is very central to successful prosecution of cases. And the first respondent, when an offense of this nature is committed, is the police institution. It is what they investigated that will be transmitted to our office, which we will work upon to generate legal opinion and write final legal advice to the police. But at times we pick up this particular investigation file transmitted to us, you go through it, you observe that there are a lot of things they don't even consider important. To them it may be minute, but to us as prosecutor, they are very germane. You just discover that it's missing there. You just discover that most of these things, they are missing in the file. So I will just run through the summary of what is expected when investigation is conducted by security agencies. Investigation is central to a successful prosecution of cases. Prosecution is always very prominent before you can get a successful prosecution in court. What is expected to be contained in investigation file? There are numerous, but I just mentioned some here. The first one here is, does the investigation reveal what should be revealed? What are the vital information that should be revealed when you investigate? Are they contained in the investigation file? Did the suspect raise any defense in his statement? In the case of gender-based violence, it is only when a child is the victim that consent is not a defense. Because normally, that particular defendant will be proceeded against under the child right law. If the defendant in that case should raise a defense of consent, is a non-issue. But when it is an adult, and the adult say, no, the person you accuse me of rape, we have been together for a very long time. He has raised a defense of consent. Was that particular thing checked by the security agencies before the file is transmitted to us and before we file our processes in court. This is very, very important. Then, were the statement of the prospective witnesses and that of the suspect duly signed by the maker and the recorder? These are equally very important. I've had personal experience where a statement of a suspect was recorded. He wasn't the one. It wasn't the defendant who recorded the statement himself. It was recorded on his behalf by the investigator. But I discovered the statement was not countersigned by the investigator. And the statement was conventional in nature. No signature, no name. It was only the suspect that thumbprinted. What of, at the point of tendering that kind of statement in court, what of if trial within trial is ordered? It means there is no nexus between the statement recorded by the IPO and that of the suspect. The statement volunteered by the suspect, recorded by the IPO. Where is the nexus? So these are the experiences we have in court. And they may look very little and minute, but they are very, very germane when it comes to prosecution of cases in court. And what is more, legally speaking, an unsigned document is a worthless piece of paper. That's the position of the law. Then, in case of this nature, was the victim clinically examined and medical report procured before file is transmitted to us? I must give kudos to SARC, Ekiti State Chapter. They have assisted Ekiti State tremendously in this regard. If medical report is not transmitted as at the time investigation file is transmitted to us, that institution is always available to assist us in that regard. We don't have difficulties with them at all. So, investigation cannot be treated with levity. Our security agencies, especially the police, is doing a fantastic job, and we give kudos to them. However, we believe that the largest room is the room for improvement in any institution. So, in our jurisdiction, we have had reasons on numbers of occasions. We have had reasons to send back to the police investigation file. We itemize what we need because cases are not won alone in court. If you want to succeed as a prosecutor, you have to put your house in order first before you file your processes in court. This is very central. So in Ekiti State, we have had courts to send back to the police investigation file while we itemize what we discover missing in the investigation file. Please do this, do this, do this, do this before you send the file back to us. Of course, this itself has legal implication because through this back and forth, time is going on. And along the line, discouragement may set in on the part of the victim or prosecutors. So, investigation is very central to successful prosecution of cases. And Ekiti State, the police are doing fine, but they still have to improve in that regard. Then the second issue that I discuss here is the attempt to withdraw cases by victim and family member. This is a recurrence decimal. And from what I've heard here today, it's not only limited to Ekiti State, it's like it cut across virtually all the states. After investigation has been conducted and is transmitted to us, you open the file, you see affidavit clearly deposed to. I'm no longer interested in prosecuting this case. It may be on basis of religious inclination and belief. It may be, you even see in the affidavit a series of emissary have been sent to me. This person may be the father of the victim, it may be the mother, it may be the relative, it may be guardian. We have had this experience series of times and still rages on basis of things like that. So we are withdrawing this particular matter. As a prosecutor, you already have a mindset that you are likely to encounter problem when you are to prosecute this case. Because that person who deposed to an affidavit of withdrawal is not likely to come to court to give evidence. And if it should come to court to give evidence, it's likely it is through coercion by the court. Yes, it will be through coercive power of the court to come to court to give evidence. At times they may come and turn hostile, even in the witness box. So I think it's a practice that must be discouraged. The police shouldn't even allow this to happen in the first place, because a victim who couldn't write a statement correctly, who couldn't even write a statement, who is not lettered at all, you will see the affidavit deposed to very neat, accurately worded. You start wondering, where is this coming on? So it's a practice that must be discouraged by police institution. Then, because although Ekiti State have persistently put their foot on ground that no, we are not going to encourage this. We have rendered legal opinion to the effect that once a case is reported and file is transmitted to the office, you cannot circumvent the prosecution of the case, and you cannot say you are withdrawing as a victim, because every criminal offense is an offense against the state. It is only the Attorney General who can say, no, I want to discontinue this case because it's constitutional. He has the constitutional power. We have not allowed the affidavit to persuade us in any form. And we have had instances where compounding felony is invoked against the deponent in that kind of situation. Then the third experience we have in our jurisdiction is securing the presence of witness in court. This is another issue, and is different from deposing to an affidavit this time around. You will see a victim of sexual violence. Civilized steps will be taken by reporting to the security agencies immediately the incident happened. But for them to come to court and give evidence will become a very big issue. Immediately the matter is reported, statements are taken from would-be witnesses and the victim. A lot of them feel that is the end of the case. But justice has not been attained by reporting to the police alone. The defendant needed to pass through the rigors of prosecution. And if we are able to sustain our case, he must be convicted and sentenced to serve as deterrence to others. But when we are ready to prosecute, you initiate calls to them. Is this case, what you hear from them is, is the case still pending? We have reported to the police. Incident like that, we have observed it and we are still experiencing it. But I will give kudos to SARC again, because this particular institution worked directly with Ministry of Justice. There was a case I personally handled. My colleague there, Ms. Rita Ilebara, is fully aware of this case. The victim in that case was hawking a delicacy. And the father of the defendant was one of the prominent customers of that victim. She went to the house of that man, who normally patronized her. The Baba was not in, but his son was around. The son observed that there was nobody at home. She lured the girl to an uncompleted building and violently violated her. When I read through the file, I nearly shed tears. The case was assigned to me for prosecution. I was looking for the victim to come and give evidence in court. The mother couldn't be found. The prosecutor couldn't be found as well. I have to resort to my colleague here. She assisted in tracing this victim and her mother to a place called Ayede Ekiti in Noye local government. Getting there, the mother and the victim, they have relocated to another unknown destination. We have to resort, if not because there are other evidence that link the defendant with the commission of that crime, he would have escaped justice. But I was happy I was able to secure conviction in that case. So, securing the presence of witnesses in court is still an issue, but we have persistently tried in our own jurisdiction to find a way around it. So I think it's an issue that must be holistically addressed, because justice in this kind of situation is very paramount to the society. Then I want to speak about the constant redeployment of police investigator. I want to believe it's a routine exercise within the police institution. But I think there is a way the police can assist as well. That before an officer is deployed out of a particular jurisdiction, in addition to what Honorable Justice Ushudu suggested the other time, that even if an IPO is transferred out of one state to the other, electronically it can give evidence, yes. But in addition to that, I think I will still appeal to police institution to see to the fact that before a particular officer who is an investigator is transferred outside the jurisdiction, they should ascertain whether he has a pending case in court. Clear your table before the deployment takes place. This will assist us tremendously. We have had instances where an IPO in Ekiti State was transferred to Cross River State. And we need to bring him down to give evidence in court in Ekiti State. You know the version it will cost us to bring him down all along from Cross River State. So, I will not call it an abysmal exercise because it's a routine thing. But I'm just saying this so that the police institution can consider our plight as well, since we are all looking for justice of survivors of gender violence. Then briefly I will speak about conventional statement. This is another area. We have it under the ACJL, and specifically under Section 9 of Ekiti State Administration of Criminal Justice Law of Ekiti State 2014. Conventional statement is one of the ways of proving the guilt of an accused person, not only in gender-related offenses, but in all offenses. Or most times, and we have lost some cases based on this issue of conventional statement, because it is now the requirement of the law, and a particular decision was handed down by Supreme Court recently that I couldn't vividly remember that case now, but it was very recent. Now, once a conventional statement is not video recorded, or the lawyer to the suspect was absent when it was recorded, should be thrown out through the window. Conviction cannot be granted and sustained on that. So I think the police institution has a duty in that regard, because at times there may be no, it is sexual related, especially sexual offenses, can hardly be proved by eyewitness, because this is not an offense that is committed in the open. At times we rely heavily on circumstantial evidence and conventional statements. So this is the area where it is very central for police institutions to create more enabling environment for lawyer to suspect and to allow video recording of statement. One out of the two will suffice, so that the conventional statement will not suffer terribly when it is sought to be tendered. Then I want to speak briefly about bail. In our own jurisdiction, though before you bring your witnesses to court, you will see that bail has been filed on behalf of the defendant. It is very, very rare. Bail is sparingly granted to victims of sexual violence in Ekiti State. And I want to believe is one of the measures put in place by our judges to discourage the menace and constant violations of rights of women through sexual abuses. So, and we have shown encouragement towards that. Instead of granting bail, what they grant is accelerated hearing. The word accelerated hearing, at times they even ask us, how many days do you need to prosecute your cases? If witnesses are available, we can say, no, we just need 4 or 5 days to prove our case. The same thing will be inquired from the defendant to ensure that the order of acceleration granted by the court is not defeated. And
is working fine for us in Ekiti State. Then we have plea bargaining. This is clearly provided for under the ACJR. But I want to say that it has not been seriously exploited in Ekiti State. Probably the defendant counsel, they are not very disposed to this. But there has been series of education to the defendants in correctional center on this, because there are laid down rules, clearly stipulated rules that guide plea bargaining. The police that investigated is involved, Ministry of Justice is involved, defendant counsel is involved, the correctional center is involved. But they have not really made use of it. And when we are talking about the congestion of prison, it will have assisted us a great deal. But we will continue to intensify efforts in this regard. Yes, there is a point I want to emphasize on the securing the presence of witness in court. I just recollect that. There was a particular case, we couldn't secure the appearance of the witness, of the victim in court. What we did was just to tender the statement she volunteered during investigation. At the point of tendering that particular statement, the judge asked, of what essence is the statement you are about to tender? We responded, the whole essence is just to ascertain that there was a complaint against this particular defendant. Of course, if you read Section 232 of Evidence Act, the statement of a witness can only be tendered for the purpose of cross-examination. That is the law. But when you look around and you cannot see the victim, what you resort to is to tender the statement, at least to establish something, that no, there was a complaint against this suspect. It wasn't just lie against. But without the particular person who recorded the statement confirming that statement on oath, it amounts to documentary hearsay. This is the area where we still have challenges. Bringing witnesses to court, especially the victim of sexual violence, is still a problem, and it must be religiously addressed to stamp out the menace of sexual violence in our society. Thank you very much.
Thank you very much, Mr. Felix, there, for giving us a wonderful presentation. Again, we're just going to quickly take contributions and questions. I can only take 3, 2, see? I was told 2. There's a lady, she's not here. I can't see her. There's a lady that, yes. Please, can I give her the mic? That's. Thank you.
Thank you and good afternoon, everyone. I'm Hafsat Abdullahi. I'm the State Project Coordinator for ROLAC Adamawa State. And thank you, sir, for the contributions from Ikiti. We are all mothers. We are some of us grandmothers, sisters, and so on. And I so much believe we are so passionate about the fight against GBV. And we are so emotional to the extent that sometimes we become myopic of certain things, either knowingly or unknowingly. What I'm trying to say is in the fight against SGBV, we should try as much as possible to strike a balance between some provisions of the law, emotions, and policies. For instance, talking about prosecuting of GBV cases, we always insist that there should be prosecution. The offender should be prosecuted. But there are policies, for instance, SGBV area of responsibility under the UNFPA policies that talks about survivor-centered approach. One of the cardinal things under the survivor-centered approach is for the survivor to make a choice of the services to be provided to her, which includes legal services, in essence, prosecution. In a situation whereby the survivor decides that she doesn't want her case to go on prosecution, you will be left with little or no option to proceed. From the point of law, you'll say that the offense is against the state or against the commissioner of police, and therefore it must be prosecuted. And you may even go into prosecution. You may investigate, do a wonderful investigation, file the case in court, then commence prosecution. But you are likely to face a challenge of the survivor and or with her family to disappear and leave you with the case file. They will just disappear and leave you with the case file. I was a lawyer on a private bar. I started from a private practice, then moved to the public bar before joining ROLAC. So I had and I have the opportunity of working in various sectors and areas. Yes. For instance, I had a case. A girl of 4 days was defiled. A baby of 4 days was defiled in Adamawa State. Yeah, 4 days. We took up the case. We started with the police. But believe me, at a point, the family came back to us to say that they are not willing to proceed. What we did was to make sure that the father, because the father was the first person to come, what we did was to make sure that the father was arrested for obstruction of justice. Unfortunately, before we could arrest the mother just disappeared with the baby. And there is nothing we can do on that. So we were just left with this person. We are alleging him of obstructing justice, whereas the victim is not there, and there was nobody to stand in as a witness. So that case has to die a natural death up till now, because the lady ran to Cameroon, and typical of the way our services works.
Okay, sir, because of time, please.
Okay,
yes.
Thank you. Then
I think
secondly, I will also want to talk on this issue of affidavits. Affidavits are just mere depositions made by individuals or organizations. You cannot depose to an affidavit to obstruct justice. So whenever we are faced with an affidavit that this person has disposed that he is not interested in the case, we should try as much as we could to sensitize him that you cannot do that, it cannot hold water. Believe me, it is those that are providing some of the services that are enlightening and discouraging the survivors not to prosecute.
Excellent. Thank you.
We have seen cases where some people in the service, in the government service, tell survivors that don't allow HAPSA to hear of this thing. Don't allow FIDA to hear of this. So sometimes we have to be careful to identify who are those hurdles, who are those enemies of progress. Then we report them to the Commissioner of Police. Let's try and build a very good rapport with the Commissioner of Police. I'm glad that the DCP said that she has provided her number, that we should reach out to her. But let me tell you something. It's not at all times that you can reach out to her. Yes. There are some times that cases come as an emergency, and she may not be available to be reached to. You may call her number, she may be in a meeting, and she may not be able to.
But I think we've addressed that. She's going to send a memo.
I would like ROLAC to support her
to have a high-level advocacy to the IG.
Yes.
The way they work as a uniformed people is that they always receive directive. So she may not even be in a position to stand before the AG to say, sir, this is the problem, you must do this. But we have CSOs working in those areas. We can mobilize them, we can support them. And they can go with her. We can go with high-level dignitaries, the Commissioner of Police, Commissioner of Women Affairs, the DPPs, the High Court judges from other states. We mobilize them. We have a high-level advocacy, and believe me, it's going to yield
I think
a positive
she's
result.
open to that.
So
and she did
that's
mention
it.
that.
Then,
sorry, ma'am. Sorry, I can't take any more contributions. Sorry.
Lastly,
that's
madam.
So sorry. Sorry, ma'am.
Okay,
sorry.
thank you.
Thank you. Okay.
Good afternoon, everyone. I wanted to ask the DCP a question, but I saw she just stepped out. I need to be spotlighted, not my interpreter, please.
Could we have the cameras to spotlight him, please? So we can have him on the screen. Thank you.
So let me start again. So I'm currently implementing a project in Anambra State in collaboration with the Intasi Center on sexual and gender-based violence awareness for deaf schools. From the Deputy Director in Ekiti State on DPP, and also I had questions for DCP Rita. She has stepped out too. She had expressed that they were planning to have a training for all gender officers across the state. I wanted to see if it's possible for them to include disability experts in that training for them to also get to learn about disability. And to our Lord Oshodi, when it comes to court proceedings and involving deaf persons, and this of course requires the victims being able to express themselves in sign language, and there are no interpreters. And interpreters, eventually, if an interpreter is involved, who is responsible for the fees or payment of the interpreter? Would it be the victim or the court? Or what skills or issues are needed to qualify someone to be an interpreter in the court in that situation? And for the DPP, the Deputy Director, the question was on your experience working with deaf people in your years of practice. How have you been? And for the training for deaf officers across the states, including disability experts, to be part of the training. Thank you.
Okay, so we can't take any more questions. We can't for now. Would you like to give a response?
Yes, especially to the one raised from Madam.
Yes, please go ahead. But how do we, because part of his question is really hinged on DCP Rita. Okay, so please can we have, please could you interpret to him that we will have those questions passed on to DCP Rita? Because she's the only person that can respond to it. She had to step out because apparently some of her colleagues were attacked in Jigawa, also about a case that she just mentioned, and they had to move them to Kano, so that's why she had to step out. But that would be passed on to her and would get the response to you. Thank you. Please go ahead, Mr.
Thank you very much. So the question raised from Adamawa State. I said in my presentation that there are 3 ways through which the guilt of an accused person can be sustained. And I mentioned circumstantial evidence. I mentioned conventional statements, and I mentioned eyewitness accounts. The case that died in natural death in Adamawa State, for me, is very unfortunate. Why? The disappearance of the victim and her relative doesn't put an end to that case. It doesn't at all. You can still sustain that case through circumstantial evidence. The police is there. If there is medical report, the doctor is there. The two witnesses, if they were available, they are enough to sustain that case in court. So, whatever it is available, you have to leverage on it. Whatever happens, even what of a situation, God forbid, if the victim is no more, does it mean an end is automatically put to that heinous crime? No, it's not a situation that should be encouraged in fight against sexual violence. So you can still hang on to circumstantial evidence, and it depends on the circumstances of the case. So that's my short response to that.
Alex, I think that's about it. Thank you very much. A round of applause. We can't take any more questions in this session because we're out of time. I'm so sorry. I'm so sorry. Thank you very much. Sir, as you go back to your seat, a round of applause for him. I'm about to ask for us to do some exercise because I can see that the sugar in our blood has dropped. Should I add some more? Maybe we would need to... Should I ask us to probably just stand a bit? Is there music that we can play to stretch our legs or something? There's a bit of, the energy is dropping, right? And we don't have that much time for our other sessions, and I really want us to take this. Can we all stand? Yes. Let's stretch a bit where we can. Stretch. Do you know where your shoulders are? You don't know where your shoulders are. These are my shoulders. So can you touch your shoulders? Yeah, this is mine. Yeah, so touch your shoulders, please. Yeah. Let's just stretch a bit. I think we're a bit. What's the name of the president of Nigeria? No? Okay. What's the theme of today's event? Of the conference? What's the theme? Okay. So are we please, let's stay together. What we're doing here is very important. I understand that, we're getting a bit tired, but I wanted to just take this short break and then we'll get back again to it. So please, you may be seated. Thank you. Thank you. This is to acknowledge the presence of the Honorable Commissioner of Women Affairs from Adamawa State, and that's Honorable Nado Jeffrey Kofulto. Thank you. Is she here? Thank you very much for being here. Thank you. We also have the Executive Director, Disability Rights Advocacy Center. She just joined us, Irene Ojiogo Patrick. Thank you so much for being here. Thank you. Okay, so to take us to the next phase, I will be inviting the Executive Director, Sustainable Gender Action Initiative, Mufuliat Fijabi, to take us through the overview of protections under the Violence Against Persons Prohibition Act 2015 and why states who adopt it must retain the spirit of the act. A round of applause for her as she comes on stage. Thank you. Okay, please, can we have the, yes.
Thank you. Okay. Thank you very much. Good afternoon, ladies and gentlemen. Permit me to stand on the already established protocol. This afternoon, we'll be looking at what we are familiar with from a closer perspective, most importantly, to get us to take more actions when we get back to our different states. So it's an overview of protection under the Violence Against Persons Prohibition Act and the various domesticated versions of the VAP Act at the state, as well as sustaining the spirit and principles of this act back in the state. Okay, so I'm going to, of course, we know a lot, much more about the Violence Against Persons Prohibition Act. That it's an act that came into existence in 2015. And since the adoption of that Violence Against Persons Act, a lot has gone into ensuring that the different states across the country domesticate the act. And that's why we're here today. We've seen several examples shared from the state level. Please, I need the remote. If it's not working, is someone moving my slides? Okay, so if we look at the scope of the VAP Act, the application is in the FCT. But the fact that we have it domesticated in all the 36 states, it's a privilege, it's a pride, it's a milestone in our advocacy against sexual and gender-based violence. And the fact that we have structures set up in the states makes it paramount that we should take a closer look at what we have obtained in the Act in itself. So for the Violence Against Persons Prohibition Act, the protection under it is quite enormous in the sense that we have a better definition of rape. Next slide, please. Next slide. We have an expanded definition of rape in this particular act, which of course we've seen the expansion at the state level, to reflect those areas that ordinarily one would not consider as constituting rape or defilement. We have inclusion of new and old acts of violence against women and men not previously recognized. I must tell us also that this VAP Act remains a reference point for us as a country, as a country who is also interested in ensuring that its citizen is protected. Oftentimes, at international fora, we have commendation, for having a law in place that is truly speaking to the issues of protection from violence against persons. And if we look at it, it's a reference point as a legal framework, that protect victims, that protect survivors as well. This is looking at the act in itself. Next slide, please. It's an effective tool also in the hands of civil society organizations. Civil society organizations actually played a key role in ensuring that this particular act is signed into law. A lot of advocacy efforts went into it. It provides enough clue in terms of establishing evidence to get good prosecution of cases reported. It serves as so-called for women who experienced violence during the COVID-19. All of us still remember that the COVID-19 period during the lockdown witnessed enormous reports of cases of violence against persons, violence against women and girls in particular. And in fact, the country declared a national emergency around violence against women. So the act was also very quite useful and protective against all forms of violence against women and girls in particular. The values and usefulness of the protection order cannot also be underestimated. Next slide, please. And if we look at the VAP Act, there are 6 sections. The part 1 we know has to do with improved definition of rape and other offenses, as well as associated punishments for those offenses. The part 2 focuses on jurisdiction of the courts and issuance of protection orders. And if you look at the part 3, it provides for registration and powers of the service providers and protection officers, etc. If you look at part 4, it provides for regulatory bodies, which we have in the structure of NAPTIP. Part 5 provides for consequential amendments to review obsolete and discriminatory laws by its general savings and repeal. Part 6, which is the last part, speaks to issues of interpretations. So, but our concern here today is to look at the National VAP Act now being domesticated into various forms of VAP Act at the state level. We have instances of states that have taken the entire spirit, the entire principle of the National VAP Act. And we have some that, just manage to maneuver their ways to have a semblance of the VAP Act. Of course, you have one complaint or the other from time to time. But we need to ask ourselves some realistic questions. The domesticated kind of VAP Act we have at our different state level, to what extent is it enabling justice, access to justice for victims who experience acts of violence against their persons? And are there resources? We've had different conversations this morning. We've listened to presentations, and we know that when we talk about resources, it's key to actually achieving justice. To what extent do states have a source of support in terms of resources, not only to get the cases prosecuted, but to increase awareness on the existence of those aspects of lives that the VAP Act has criminalized? And if you talk about support for victims, it's also there. You talk about prosecution, punishment for offenders. Some of the VAP Acts, if you ask in those states, there's no even costed provision in terms of what would it cost to implement this state VAP Act. So if you don't even know what it takes to implement a particular law that is so crucial, how would you have a sufficient budget line for it? If you look at collaborations among stakeholders, is this obtainable at the state level? From our conversations since morning and since yesterday, we've seen that there are still gaps. There are still gaps within states, looking at prosecution, looking at the police, looking at SARC centers, looking at civil society organizations, looking at media. To what extent is collaboration making it possible for those domesticated VAP Acts at the state level truly effective? When we have laws in places, it's not just sufficient to sign it into law. To what extent is it operational? It's a question for us to take back. And do we have the necessary structure in place? In some states, the laws are just there in the books. And maybe reference is made to it from time to time. But is there a structure to enable it move, to enable it reach the citizens that it's meant for? So these are some questions that we need to continue to ask. And to what extent is documentation going on? When cases are reported, what is the documentation process around it? Is there a central data collection? Is it still a case of we get some data from Women Affairs, we get another from the police, we get another? At times, some of the cases being reported are even the same. So what about us striving further to ensure that the principle of the VAP Act is maintained and is upheld? Maybe if we don't remember the story, at least I was part of the civil society organization. I know that the cry then was to get a law to punish those who commit these offenses, especially rape, especially sexual and gender-based violence. And that's why in the course of struggle and advocacy, you found that the sexual assault and referral centers They came into existence before the VAP Act itself. I'm sure we are aware of that. We had the SARC centers before we had the law that actually also supports the kind of job that they are doing. But today, the VAP Act is domesticated. Why is it not moving so fast at the state level? It's not enough to have a law at the national level, but it's even more important for us to have it work maximally at the state level, to ensure that the spirit of getting and having that law in place actually gets its maximum benefit. So one of the principles recommended here is setting up of effective structures in the state. So you're all key stakeholders, you are important back at the state level. If the VAP law in your state, no matter the kind of version that has been domesticated, is not working, why is it not working? Do we have the structures that should be there? And if it's not there, what should be done to make sure that it is done? Institutionalization of resources. Having a process that makes response to XGBV ad hoc in terms of resources would never get us anywhere as a country. I know that the police was put on the spotlight in terms of to what extent do they follow cases, and we listen to the challenges around resources. What about the SARCs? So if there is no deliberate political effort to ensure that resources are channeled to ensuring that those laws are implemented, to ensure that there is adequate response, it will remain a challenge. So we need to move above that. We also listened to the conversations around budgets yesterday, and the need to interrogate the process. So where would the budget line be? I know that to get resources to fund efforts of government, there must be a budget line. If not, you cannot move from where you are. So, and the resources is not just for prosecution, it's also about increasing awareness about those aspects that have been criminalized that people need to be aware of. We have seen from past interventions that when you talk about sexual and gender-based violence, there's also a mentality around it. There is a mentality around it. To what extent can we get a change of attitude which will lead to a change in behavior? In those days, people used to say that, why did the woman wear a short miniskirt? Or she wore a miniskirt, or she wore spaghetti, that's why she was raped. But we just listened here today that a 4-day-old baby was defiled. That calls for questioning and reflection. So the resources we are institutionalizing is not just to continue to respond. Yes, it is good to get justice for victims, but at the same time, we need to step up action on prevention, on raising awareness, on increasing media visibility on reasons why these offenses must not be committed. So the best way to go about the resources is to cost it. We need to know how much we are spending before we can get a budget line. So it's important, and we should also create and facilitate budget lines for it. I've worked in an institution that is supposed to be government supported before, and because there's no budget line, nothing comes to that institution. And the institution has been surviving on donor support and funding. And every time you raise it, they ask you, where is the budget line? So we must get that clearly for those of us responsible for that. Accountability is critical. You know, I like when we have data and statistics on our response to XGBV. At the state level, we need to increase action around that. We need to increase action on our process of cases reported, prosecuted, cases completed, and victims who become survivors. Most times we're dealing with victims. At what stage did they become a survivor? We also need to document that, because somebody can remain a victim for life, and that's not good enough. If we respond to SGBV, the victim must at some point transit from being a victim to a survivor. That should be our ultimate goal. So the person begins to live a normal life, the person becomes empowered. Who is providing that support? After getting justice that is desired and deserved, what happens to that victim? Has she or he completely, moved into becoming a survivor? So we also need to incorporate this at the state level. So it's also important to ensure that we consistently make the state VAP laws responsive to emerging trends, issue of climatic change, banditry, kidnapping, acts of terrorism, online sexual and gender-based violence. We need to make the VAP. So at the time the National VAP Act becomes reviewed and is amended and signed into law, the state should also be ready. I'm very hopeful that the stress that everyone went through getting the states to adopt the laws at the state level will not happen when the National VAP Act itself advances, and that it will still bear those critical areas that will continue to provide support and protection for the citizens. So, creation, support of sexual assault referral centers. As at today, based on ROLAC findings, we have 47 sexual assault referral centers in Nigeria. That is still not enough. To make it worse, some states don't have any SARC presence. And these are some of the states: Oyo, Imo, Abia, Plateau, Bauchi, Gombe, Osun, Kogi, Benue, Katsina, Zamfara, Ondo, Nasarawa, and Taraba. They don't have any SARC presence, which is not good enough. So if we have their representatives here, it will be very helpful to begin the process. It doesn't cost much, but it will save a lot of lives. So sufficient documentation and data, that has been mentioned, consistent capacity building for stakeholders involved in the implementation. This has been mentioned over and over. There is need for training, retraining. There is need to not assume that, Shebi, we trained you 2 years ago, you don't need any more training. The world is changing over times. The enormity with which the online sexual gender-based violence came has shown us that all of us need to go back to training, and all of us need to improve our capacity to be able to respond to that. So SGBV, violence against persons, is not something that we close our eyes and say we have arrived. No need for more information. We need to do more and learn the new dynamics around it to be able to respond. And this is the challenge to all of us. We must ensure access to justice for all and ensure that no one is left behind. We must continue to support victims and survivors. There should be continuous interagency collaboration within states. We all see the tension amongst the agencies at times, but this is not enough. So we're looking out for more and sufficient collaboration with various agencies of government, women affairs, health and social welfare, judiciary, education, law enforcement agencies, media, and the rest of it, and civil society organizations. If we look up at this data, I got it from the dashboard of the Federal Ministry of Women Affairs as of June 2024. We will see the extent of reported cases per state. This reflects states who have given reports. And if we look at it closely, since 2020, it has been on the increase. There is no decrease, which means that the states need to be actively involved to achieve overall effective zero tolerance to SGBV. if we look at this second one, we can see the bar of states that are on the increase. If we look at Benue, for example, there's no presence of SARC there, and it's one of the states. I'm not just spotlighting negatively, but we need to learn from the information that data give us in terms of re-strategizing, in terms of going back to the drawing board to do the needful at the state level. For example, to establish a SARC, what you need is the commitment from 3 key ministries, Women Affairs, Judiciary, Health. If they meet to sit that they want a SARC center to be created, for example, it will work. It will happen. And if it happens, it had values to enhancing access to justice for victims, who may need to get the support that a SARC can provide for them. So we've seen several examples of progressive happenings, since yesterday. We listened to a lot from Lagos today. We've just heard from Ekiti. And the judge from Anambra also spoke about our efforts yesterday. And Adamawa is one of the states with the forensic center. And then FCT, Kebbi, I was very impressed with the efforts going on in Kebbi around responding to cases of SGBV. We also listened to someone from Sokoto yesterday. This shows that the states can deliver on prevention and protection of citizens from violence against their person, especially sexual and gender-based violence. So we're not talking in abstract. It's a realistic thing that is achievable, that also can stand the test of time. If states evolve to review their commitments to the fact that the citizens need to enjoy the benefits of the VAP Act that has been adopted in each state. So this is my conclusion. The VAP law, as domesticated at the state level, deserves more attention in order to enable the process for maximum protection for citizens and to ensure a consistent drive towards zero tolerance to all forms of violence against persons. And I always had, especially sexual and gender-based violence. So this is an assignment for all of us to go back to our state, to reflect on the key takeaways of this meeting, to continue to identify with the fact that when you talk about protection that the VAP provides, it's not something that we can take for granted. It is important. It's going to add to the value of our state and our country in the effort to ensure that the citizens are free from all of those offenses prescribed in those laws. Before I round up, I'd like to generally commend all of us for sticking our necks out, even at the risk of it, to ensure that we get justice for victims of violence, victims of sexual and gender-based violence. At this point, I'll stop. And
thank you. Please, a round of applause for that. A round of applause. Okay, we'll just take 2 contributions again or questions, and if we can try to direct our questions and contributions towards the presentation that she gave, that would be great as well. So I will come to you.
Good afternoon, everyone. I'm Aisha Rufai Ibrahim, Commissioner for Women Affairs and Social Development, Nasarawa State. Nasarawa State government has established a SARC center in the teaching hospital, the University Teaching Hospital. And that is in our desire to improve access to victims of gender-based violence. And His Excellency, the Governor, has approved an overhead cost for the running of the center.
Excellent.
It's a small center. We are not there yet. We'll continue to learn from places like Lagos and other states that have been working on that for a very long time. And we also need to train the staff of the center. We appreciate if we can have volunteers here, even if it's or ROLAC, if they can help us to train the staff at the center. Thank you so much.
Thank you very much for that contribution and request. I'm sure that that is also taken into consideration. Please, thank you.
Good afternoon, everyone. My name is Linda Dirisu. I'm the newly appointed SARC coordinator of Benue State. Seeing that we're taking just 2 contributions from this section, I had to quickly raise up my hand. Because looking at the graph there, Benue, it's a big cause for concern. And I'm happy to say that the state government has been very passionate. The newly elected governor has been passionate about taking up and making sure that the center work. The center, we have always had a center, well, not that it's been established for too long, but it did not, it hasn't been operational. And now we have a new government, and he's very passionate about making it work. Just like the commissioner spoke about Lafia, we also want to plead that we're not being left alone. The fight for gender-based violence is a collective effort, and we also have the center readily available. But presently, what we need at the center, we need equipment for it to work. And we also need staffs to be trained. So it's a good news to see that we have the center back. And as the coordinator of the center, I'm going to work tirelessly to see that we work closely with all the CSOs, NGOs on ground, and ministries to see how we can bring down the level of the graph. Thank you very much.
Thank you very much.
Thank you.
Thank you. Philip, would you like to just give any final words?
Okay, thank you. I'm very happy to know that Nasarawa and Benue State have centers that are yet to be fully operational. So seeking support to make it operational is not out of place. And for Nasarawa, they already have the governor approving some budget lines for them, which is good. I believe this is a platform for further networking to enable those SARC centers to meet the required standard. And I would also encourage that for the SARC centers, they should continue to be in the center of getting the required equipment to enable them perform the roles that we all expect from them. You know, getting justice through them is also a desired result and outcome. Thank you.
Thank you very much. Thank you. Thank you. A round of applause for her still. A round of applause. Thank you. Okay. So according to our program, we are supposed to go for lunch and then to come back. But I thought about it that no, we can't go for lunch and come back because you may not come back. And based on data, you know, that we've gotten over time for other forms of conferences. So we're like, no, we have to keep you here. So based on that, we are going to take the very last session that we're supposed to take after lunch. And I would like for us to really give our attention to this and engage and contribute as well. Because if we don't do that, you probably would not have your tickets for lunch. So please, right? So we'll do this and then we can wrap up the day. So please, at this point in time, allow me introduce and bring forward to the Executive Director, Disability Rights Advocacy Center, that's DRAC, Irene Ojiogo Patrick. She'll be talking about a survivor-centered approach, emergency response, social support and justice for survivors with disabilities. A round of applause for her. I'll get another mic. Yes, please, just here. We didn't. Can I have the other mic? Thank you. A round of applause for her. Thank you. Yes, I'll get that. So just to... 1 second. We're using the screen for the slide, right? So she can... There you go.
Thank you. Yes. Okay, so good afternoon, everyone. And let me just say that I'm happy to be here to speak to something that is very important, something that is usually missing in our conversations, but which should actually be taking center stage when we talk about sexual and gender-based violence. So I'm going to try, because I've been told that I don't have much time, so I'm going to try to be very quick. Which way am I? Where are the slides?
And maybe if this is not working, to listen to her when she says, change slides.
Okay, fine, thank you. So I'm sure, you know, in the course of our work, we would all have come across issues concerning persons with disabilities. They also face violence, just like every other person. But many times, their issues are forgotten, their issues are not planned for, interventions are not focused or targeted at persons with disabilities. However, they face unique barriers when it comes to accessing sexual and gender-based violence services. And for me today, I'm going to be talking about what a survivor-centered approach means for those of us with disabilities. We'll be looking at practical solutions that ensure that services that are provided in SARCs are equitable, inclusive, and effective for persons with disabilities. So just for you to understand the landscape, a few statistics that I think will be helpful. Persons with disabilities are 2 to 3 times more likely to experience SGBV than those without disabilities, yet they continue to be invisible. And of course, women and girls with disabilities face the highest risk of violence due to the stigma associated with already being a woman with a disability. And of course, many of us are also dependent on either caregivers or our intimate partners. What are some of the barriers that we face? Definitely physical barriers are one of the most serious barriers, where facilities are not accessible, medical equipment are not accessible. I just want to believe that none of us here is a total stranger to the issues that affect persons with disabilities. That's why I'm not going into too many details about how medical equipment are not accessible, how buildings are not accessible. I just want to believe that we all have a basic understanding of some of these issues. So because of time, I won't go into too many details. And of course, there are communication barriers where we have lack of interpreters, lack of assistive devices, and communication that is not in accessible formats. And then we have the systemic barriers, focusing now on the institutions where the staff are not trained, there are no friendly policies and guidelines within the institutions. These are some of the barriers that persons with disabilities face. So what is an emergency response for survivors with disabilities? The principles for us when we talk about an emergency response has to do with accessibility, dignity, and autonomy. First of all, the service has to be accessible for us to even be able to access the service or, even walk into the center. Unfortunately, a lot of our services are not physically accessible. And then there's also the issue of dignity. Many persons with disabilities still encounter attitudinal barriers on the part of the service providers, where you're still treated with a certain kind of debilitating behavior and all that. I always give the example of whenever I would go to a hospital, the service provider would not talk to me. They would rather talk to my driver, who just wheeled me in, and ask the driver what is wrong with her while I'm standing right there. They would rather talk to the person you're with rather than engage with you. It's about lack of, or feeling that persons with disabilities do not have the capacity to explain what is wrong with them, to tell you what they need, and of course, like I said, this comes from that age-old thinking that, we should only be treated as recipients of charity, recipients of goodwill. Every time you see a person with disability, the first thing that comes to your mind is, hey, sorry, hi, why now? Hey, in this your condition. And then you forget that the person needs to first of all be treated with dignity and not pity. And then mindsets about persons with disabilities, we're not treating them as people who cannot make informed decisions. You're only supporting them to make the decisions. You're giving them all the information they need so that they can make their own informed decisions. Decisions should not be taken for them. There's always the tendency or the temptation that when you encounter someone with a cognitive disability, for instance, you're tempted to say, oh, the person cannot communicate well, let me just help them make the decision. That is not one of the principles of inclusive response for persons with disabilities. Practical steps that we can immediately take is when we go back, start with conducting accessibility audits in your facilities. An accessibility audit can be quite broad. It assesses not just the physical parameters of your facility, but even your policies, your staff, the communication. It is quite holistic. If you're able to effectively conduct an accessibility audit, it gives you the first step towards beginning to make your services inclusive. And then, of course, staff must be trained in disability-sensitive emergency protocols, which would also include communication methods. What are some of those protocols? First, we must have accessible reporting mechanisms. One of the reasons why persons with disabilities do not often report or readily report is because the reporting mechanisms are not accessible. Many of our hotlines are call-in hotlines. You say, oh, call in this, that. But the deaf cannot do call-ins. They have to text. So do we have text-based hotlines for our deaf survivors? These are some of the things we should begin to think about. What your reporting forms that are online, are they compatible for those who are visually impaired? Are the staff available in the centers trained to assist those with intellectual disabilities? Why does this matter? Because many survivors continuously face barriers in communication. And of course, that will have a huge impact on reporting. Many times, SARCs will tell you at gatherings like this, they will tell you, but we don't see them. They don't come. When ROLAC first started engaging with persons with disabilities years ago, the constant thing we were hearing from the service providers was that we don't see persons with disabilities. They are not there. The problem is your services are not accessible. So if the services are not accessible, why would they come? They have no reason to come. And so they continue to be at the mercy of family members who want to settle, community leaders who feel, oh, as a person with disability, you don't even have a right. You should be, things should be swept under the carpet when it comes to you. But if the services are accessible, then you will definitely see persons with disabilities coming to obtain your services. And then we have immediate provision of assistive devices. How many of our SARCs here after actually have functional, good, clean wheelchairs in the SARC, or a crutch, or a white cane, or something? Sometimes persons with disabilities who have just undergone rape or assault or something can come to your service and they don't have the assistive device. Take me, for example, without my wheelchair, I cannot move. So if I come without my wheelchair, they carry me out of a vehicle to come and access your service. Do you even have a wheelchair that I can use immediately? Sometimes we could come with a damaged wheelchair that is even not safe for us to use. Do you have any assistive device in your facility that a person with a disability can immediately use and get the treatment, the attention that they need, and then sort themselves out later? So it's important to know that having assistive devices is one of the, for us, emergency protocols that should be in place within the facility. And of course, like I just said, this matters because, you know, people can come in needing help and they don't have their assistive device. You should be able to provide. And then, of course, looking at the service, the actual care that you are providing, is it disability sensitive? I talked about all the gamut of accessibility we face. People in wheelchairs do not get weighed in the hospitals. They have to keep carrying them from their wheelchair onto the examination couch, onto the hospital bed, and all of that. Carry. When somebody is not a sack of gari. And then sometimes it gives room for some kind of veiled insults. They say, Madam, you have you. Start running commentary on things that should not be their issue. They should be focused on the assault or the trauma that you went through. Which is why one of the things we say is that facilities need to even, inclusion starts from even when you're doing your budget, your procurement. What kind of equipment are you procuring? It doesn't just start at training the staff to know what to do, but inclusive budgeting. Are you including reasonable accommodation? Are you including disability reasonable accommodation within your budget? So that when there's a need, you can pay for a sign language interpreter to come in and do, or you can even hire one, or have one, you know, on speed dial that you can call up at any time to come and render a service for you. And of course, you have to always know that most persons with disabilities require their personal aid or companion or assistant. And it's necessary for them to have such people to accompany them when they are coming to access your service. But also bear in mind that this person could also be the abuser. So you also have to find your ways of navigating around situations when a person with a disability is being abused by their caregiver or their intimate partner who is also accompanying them everywhere. You need to be able to know how to get the required information, you know, from the person without also further aggravating the person's situation. I've talked about communication. We need to make all our communication, not just the information that is passed from the service provider to the individual at the time, but even our promotional materials, our informational materials. When we're talking about, SARC services are present here, SARC services are open from this time to this time, come and access it. Are we thinking around how accessible that communication or that information is for persons with disabilities? Are you thinking about the deaf? Are you thinking about the blind? Are you thinking about the deaf-blind? Because just as our disabilities differ, so also do our challenges differ. I am a polio survivor. My challenges have to do mostly around mobility issues. It is totally different from someone who is deaf or someone who is deaf-blind. Even someone who is deaf, their communication needs are totally different from someone who is deaf-blind. But we find that there's always that temptation to paint all of us with one brush. The media always call us physically challenged. Most people who are now trying to show that they are being inclusive call all of us persons with disabilities, but do not take the time to ensure that everything is accessible for the individual. Sometimes you need to actually tailor your services to the individual person with a disability. I gave an example at a meeting where myself and another wheelchair user were at a meeting, and it was time for lunch, and my own condition warrants that after I've sat upright for like a few hours, I need to stretch out. So when it was time for lunch, I said, please, could they bring my food to the room? And the server, the people at the restaurant said, no, look at the other woman with a wheelchair. She came to the restaurant. Because they assume that what affects this person affects this one the same way too. But our issues are totally different. She has spinal cord injury, I am a polio survivor. She has what she's going through, I am going through PPS. You cannot paint us with the same brush. Many times people will say, but we made a room for ramp now. What about toilets? Abi, I will sit here from morning to night, I will not enter toilets. And then the toilets are not accessible. Even when they go ahead and make provision for accessible toilets, those of you without disabilities will still go in there and mess up the toilets that are reserved for those with disabilities. I cannot stand over a toilet. I have to sit, which means the toilet must be clean enough for me to sit. But you feel that the toilet is, you will catch something if you sit on it, and you can stand. So you stand and you spray urine everywhere. Apologies for going so detailed, but I'm just trying to give, accessibility is not only about put a hand ban, even our attitudes towards things. You that you can enter the toilet that is reserved for people without disability, you will leave that one. You will enter the one that is meant for those of us with disabilities because it's very clean, it's very spacious. You go in there, you stand, you pee, you spray pee everywhere, you don't clean it up, you leave it and you go. Now it is my turn, I need to use the toilet. And I go in there and it's messed up, I cannot use it. Two things can happen. I either turn around and go home, or I go back and keep waiting until the meeting ends. And then in the process, I'm also, holding on to pee, which will be affecting my bladder and so many other things. You do not know the struggles many of us go through. You cannot even begin to fathom many of the struggles some of us go through, even to attend a meeting like this. Because you have to think about so many things, think about this, think about that, or is it transportation we want to talk about? If we continue, we will not live here today. Also, one of the protocols is ensure that you are counseling, your counseling for persons, survivors with disabilities is also done inclusively. Let them be able to understand what exactly the information you're giving them so that they can also arrive at an informed decision. Bear in mind that disabilities present themselves differently. Sometimes what you see as somebody not responding to your counseling could be the person not understanding what you're saying. So you really need to settle down and walk through emotions and language barriers, communication barriers with some persons with disabilities before you just write them off and say it's not easy working with persons with disabilities, because that's some of the commentary I get at the same time from service providers. They will say it's not easy working with you people. And of course, like I said earlier, some persons with disabilities are trapped in their situation, abusive situation. you as the service provider need to help them work out their safety, especially when they have mobility challenges. Sometimes the way some caregivers who are abusive to women with physical disabilities, what they do is they can snatch away your wheelchair or your crutch, knowing that that is your means of mobility. Snatch it away, throw it there, and then pummel you, panel beat you, knowing that you can't even crawl out to go and get the wheelchair, or some even damage the wheelchair. Are we recognizing some of these types of abuse in our work? Sometimes there are various layers of the kinds of abuse or SGBV that persons with disabilities go through, which is sometimes not recognized. I want to believe that the police have changed or are changing, because one of the biggest challenges has been with the police. A blind woman was asked when she went to report that her boyfriend beat her and she wants him to be arrested. The policewoman called her aside and said, "This man, he don't take away, he know you." She said, "Yes." "He know you for this condition?" She said, "Yes." "And he keep you for house for this condition? And you say make the arrest her, you be wicked person." A policewoman. So as far as she's concerned, the man has done you a favor by keeping you in his house. He saw you in this condition. It's not like he married you whole and then you became blind. He saw you in this condition, did you the favor of marrying you, and now you want to report him so that they will arrest him. She said, "Go home and go and settle with him." So that's why I'm saying, again, I'm not trying to indict or torchlight the police, but I'm just saying that these are some of the experiences we've had. So once we get into the mindset that persons with disabilities, especially women and girls, are more vulnerable, we should also, once you see them, you should also begin to think around how can you help them be safer. We need to do some level of safety planning with them, because it might also be that you could have you could make the decision that they should be in a shelter. But if that shelter is not accessible, she cannot stay there. She will still need to go back to that person who is her caregiver, who also is her abuser. How do we, strike a balance? What do we do? And I don't think the answer is for persons with disabilities to answer. I think the answer is for service providers to answer. How far and wide are we thinking? Even my sister said the VAP Act will soon be reviewed. Are we thinking of putting things in place that will address such situations, such scenarios? Also, I just mentioned providing accessible safe spaces or shelters, that persons with disabilities can access. And of course, this is very important because, like I said, there's no one size fits all. Sometimes you might just decide, in fact, most places, their solution to accessibility is put a ramp in front and bring sign language interpreter. And they will tell you, we are very accessible, we are very inclusive. But that's just scratching the surface. And I'm also an advocate for multi-agency collaboration. Don't ignore organizations of persons with disabilities in your state, in your community. Don't just see them as these people. There's always the tendency to look down. You might not even know that you are doing it. When you see a person with disability, your first reaction is to give them something, is to dash them something, or pray for them. Yes, it works to my advantage sometimes. I'm always sharing the story of when I went to immigration to go and renew my passport. And, as I just came in, I think she was a boss in the immigration. As soon as she saw me, the queue was very long, and these people on the queue, they are not interested in what the Disability Act says about being first in the queue. They no send that one. But the woman, as soon as she saw me, she said, hey, come, bring her. And as soon as I came, she said, you are healed in Jesus' name. Take her, go and do your part, go. And I was in and out of there within 45 minutes. So in that case, yes, I like that. But that shouldn't be the standard. You shouldn't just judge persons with disabilities just by seeing them. We have so much to offer. In fact, I don't even want to begin to talk about what persons with disabilities can do, because it looks like I'm being patronizing, we're selling ourselves. But so those of you that have really engaged with some persons with disabilities, you will know that we are not as helpless and unproductive as people tend to think. It is our interaction, or the interaction of our impairment with the barriers in the society that has made it seem that way. Remove all the barriers and you will see persons with disabilities living to their fullest potential. So I was talking about the fact that we need to collaborate. Organizations of persons with disabilities, healthcare providers, the justice service providers, the police, everybody. We need to be talking to each other. We need to be working together to ensure that those of us who have disabilities are not left behind. We're not left out of the access to justice. And this is also very important, monitoring and feedback. Are you even, that 1 or 2 times that you have encountered a person with disability accessing your service, are you even getting feedback from them about how well or how badly they received a service from your facility? This is extremely important. This is the only way you can improve your services. You can improve what you're offering. When you take the time to hear from persons with disabilities, what was your experience like? How was it? Did you like this? Did you like that? Or was it easy to access? Was it difficult to access? So that they are giving you feedback about what their experience was, and you can apply that feedback into improving your services. Social support is also necessary for persons with disabilities. We need emotional support, physical support, community engagement. I think in between I've spoken about all of this, how important it is to ensure that physically the environment is not inaccessible, and engaging with organizations of persons with disabilities. We have to train counselors in the SARCs on disability-aware trauma care, partner with disability organizations, develop accessible resource materials. I've mentioned this as well. It's important that our resources that we use in our day-to-day also think about persons with disabilities. Sometimes it could be just making it large print, it could be making it audiovisuals and all that. What is justice for persons with disabilities? First of all, in terms of barriers, these are the barriers. The barriers are standard. They don't change across all of the sectors. The barriers remain the same. Physical inaccessibility of the courts and legal offices. Apart from physical inaccessibility, even getting legal aid is also out of the reach of many persons with disabilities. Because again, believe it or not, persons with disabilities are some of the poorest of the poor. Just by virtue of living with a disability, you find that you are unable to sustain your resources on the same level with other people. Coming here alone, I cannot take along, is it along they call it? If I don't have my car, I must jump, I must enter Bolt. Bolt, you know how much Bolt is now. And of course, even if I have to enter along, I'm coming with my aid. They will carry my wheelchair. And so the drivers even charge more. There are so many different extra layers of things that increase our vulnerability, even around transportation. So now imagine a lawyer, you have to get legal services, you have to pay an interpreter if you're deaf to interpret for you. The lawyer, you still pay lawyer's fees and all of that. So it's really a challenge with a person with disability to actually be able to manage their resources, to be able to grow and become a billionaire, particularly in this economy. So if you know this economy is hitting you, take whatever it is doing you, times it by 50. That is what is hitting those of us with disabilities. In fact, 50 is small. I would say times it by 1,000. That is how hard. You will not understand. You will not. Okay, so lack of accessible legal documents. I remember that there was a time ROLAC took the pain to train interpreters on legal terminology, you know, so that when they are interpreting for the deaf, they are giving them the right information, because many people do not understand some of the legal terms and terminology that are used in the legal processes and all of that. Again, remember that because of this historical discrimination and exclusion of persons with disabilities, many did not go to school in time. Many did not even go to school. So there's still high rates of illiteracy. Yes, because parents used to hide their children with disabilities. They still do it. So some of them first entered the four walls of a school at the age of 21. So imagine that person is called to come and sign legal documents. They don't even know what they are signing. So what we are actually doing is we are just trying to play catch up, because we have been excluded for so long in every way you can think of. Principles of inclusive justice. The survivors must be empowered, must feel empowered enough to fully participate in their justice journey. There must be reasonable accommodation. Courtrooms, law offices, legal offices, all of that have to be made accessible. And of course, fairness. There's also this thing about not believing persons with disabilities. A blind girl that is raped says she knows who raped her because her other senses are heightened. She knows his voice, his smell, his this, his that, and they will tell her, shut up, how do you know? After all, you're blind. This is a big challenge. It's a huge challenge, and it keeps recurring. And so you see a lot of persons with disabilities are not getting justice because there are issues around their believability, their credibility. So what are some practical steps we can take as SARCs? We can begin to collaborate with legal aid organizations to ensure accessible courtrooms and legal representation. We can begin to support those with cognitive disabilities to be able to make their decisions themselves. Remember, this is a very tricky situation. Someone with an intellectual disability or a cognitive disability, already there are challenges with communication, understanding, and all that. So how are we ensuring that we're not imposing our own decisions on the person, and that it is the person that is actually the one making their own decision? And then, of course, training legal personnel on the rights and needs of persons with disabilities. And I want to believe that the legal personnel, they are mostly lawyers, judges, all of that. They know the laws, but they do not really apply them to persons with disabilities. What is the role of SARCs? Conduct regular accessibility audits of facilities, train staff in disability inclusive practices, create partnerships with disability organizations, and then adopt a proactive measure to ensure that no one is left behind. In one of the trainings recently, I talked about even thinking around mobile SARC services, so that for those who are not even able to leave their homes or move out of their environment due to one disability-related challenge or another, they can also access services. And of course, I just mentioned some of the ways we can begin to measure whether our services are effective or not. When we are able, some of the indicators of our success, when we see that survivors with disabilities are more and more accessing our services. I want to believe that if you make your SARC service, your SARC facility accessible, you will see an increase in survivors with disabilities coming in. Because we also, on our own part, we do our own outreaches within the community and encourage them to go to SARCs. This is a SARC, this is where you find a SARC, go there. But if they get there and the services are not accessible, then they cannot access the service. Also, like I mentioned, when you get positive feedback from survivors about the quality of your service, when we have successful legal outcomes for those with disabilities, imagine someone who raped a deaf girl or a blind woman being actually prosecuted and being convicted. Those are the kind of success stories we want to be hearing, to know that yes, the justice system is also inclusive and responsive to persons with disabilities. I'm almost done. And then, are we collecting data that is disaggregated by disability? That is also very important. It will help us with our planning, our budgeting, and ultimately our programming. Yeah, I think basically, in conclusion, a survivor-centered approach for us, for persons with disabilities, is not just about accessibility. It's about equity, dignity, and justice. And SARCs must lead the way in creating inclusive services that truly leave no one behind. Thank you.
Thank you. Who got to learn something completely new today from this presentation regarding how we relate with people with disabilities? Like, there were things I thought I knew and I'm like, oh gosh, no, I didn't see that, I didn't see that. So thank you so much, Irene. Thank you so much for giving this wonderful presentation. And no, please, you can please stay there to respond to some contributions or questions. I will not take 2, I will take 4 this time. But please, if you're going to be speaking, no long story, just go straight to the point so that we can accommodate more people, right? So I will let me take a question from you. Yes, thank you. Or a contribution. Go ahead. The mic is with you. Thanks. Is it on?
Okay.
Yes.
Good afternoon.
Good afternoon.
I'm overwhelmed. My name is Comrade Kaura Joseph Wakili, the Social Welfare Secretary of Joint National Association of Persons with Disability in FCT chapter.
Thank you.
In addition to that, all these things, why we face some barriers in most cases is because some things the policies are not being carried along with us. If some decisions are being taken, if one of us is been there, we'll be the one to say, okay, see, if persons with disability is invited, the transport stipend should be more higher than able people. So that is my addition to her on this thing.
Okay.
Sorry, I wanted to ask a question.
Okay.
Directly to the police woman. Oh, is she still there?
She's not here, and we will
Okay.
probably take that another time. Sorry. Would you like to address anything he said, to either correct or?
Well, I think I get what he's trying to say, because of the challenges maybe that events like this should consider increasing transport fare. But I think what happens is you're actually allowed to come with your assistant or someone, and it's also paid for.
Okay.
So while we might not be going as far as say increase transport fare for persons with disabilities, we also want reasonable accommodation,
right,
whereby that whatever challenges are making it difficult to participate are also removed or addressed.
Thank you.
Sometimes it might be what he says, but most times is about coming with your aid, coming with your
And they're
this,
also
and they are
accommodated
also
as well.
accommodated as
Thank
well.
you. I'll take you. Please, the mic.
I'm with the mic.
Yes, but I'm giving the mic to her to speak. I will come to you. Thank you.
Thank you very much. My name is Rita Ilewai. Thank you for all you do. You know, there was a time you trained us SARC manager. It really helped us in our own SARC. Before then, we just used to say persons with disability. It was after that training that we used to disaggregate very well. And we now took it upon ourselves when we have outreaches to not just say, just come and report. We also say persons with disability too can report. And that increased persons with disability, even though our facility is built for purpose and very accessible with interpreter. But in addition to that, what inclusive of persons with disability does is they are not only victims, they are also perpetrators. Yes. So we have also recorded cases where it is the persons with disability that are the perpetrator. In this case, it was even a deaf person. So the interpreter at the SARC also helped in ensuring that the case was well investigated. So being inclusive is a win-win for everybody to ensure that justice is done to all parties.
Thank you. What state did you say?
Ekiti.
Ekiti State. Thank you very much for that contribution.
I just want to respond to what she said, that disability is not any excuse for criminality. So if a person with a disability is the perpetrator, by all means, throw the book at them. They should answer for it as well.
Thank you.
All right.
Okay.
Thank you so much, Dr. Irene. That is a wonderful presentation. My name is Bilkisu Yakubu. I work for Advocacy for Women with Disability Initiative. Just last year, because when Dr. Irene is making her presentations, I was just imagining, we lost a woman with disability, Aisha Aminu, to the code out of death due to gender-based violence. And she has reported this case for several times. We took it upon ourselves. We worked with the vigilante group and the police officer to give her a support where she needs. And every time this same man, the man that perpetrated this evil is her husband, her fiancé, and they've been together for 5 years. So imagine if the police should have taken this case over, maybe issuing a restricting order, avoiding the man from getting close. Maybe today, Aisha Aminu will be alive with her 3 beautiful children. But she was killed to the cold hand of death. We lost Aisha Aminu on the 7th of June, 2023. And there was nothing we can do. We took it upon ourselves. We're advocating, protesting. We have to block the government house in Kogi State to ensure we get justice. When this incident happened, the perpetrator ran away. And how did there was no tangible evidence. How did we get evidence to even... We had a radio program where we make it open for everybody to call in. And the murderer, maybe because of illiteracy, he called in. And that was the one basic evidence that we were able to use. And then when we noticed that the case is going left and right, and there is nothing we can do about it, we have to start going to government house, blocking the road and all that before 27, exactly June 27, 1 year, 20 days, and the justice was served. So, and we went through a whole lot of stress. We have to take money from our pocket. So if we have this approach, and we have these SARC centers, maybe in our state, it will be better. We can easily liaise, our organization can easily liaise with them, and then maybe today Aisha will be alive. Thank you so much.
Thank you so much for that contribution. Kogi State, my state. Yes, can we take from the officer? Yes.
Good afternoon. It's a lot. With this, maybe I will need to get your phone number. I'm sure I'm CSP Rosemary. I have a case at my desk. A blind woman came. She was led by her first daughter, complaining her present husband. She had a husband before he died, and thinking not being alone with her children, getting a somebody she could rely on would be better. But alas, this man beat her to the point of getting her blind. Yes. So maybe I'm going to get your number so that it was so pathetic that the moment she came, we dropped her petition. My madam, who had just had an emergency call, took it to the DIG by herself. Immediately it was approved. I don't know whether she went home and said one thing or the other. The guy weeks away. So the IPO had to exchange number. We had to prepare a warrant of arrest. Up till now, we have not seen him. We are the one calling her once in a while to give us info each time he's around. They say the man is notorious and so on, but that is not a disturbing fact. I, by myself, by the grace of God, I will lead that. Because when you see this woman, oh my God, the man is even saying, let me marry your first daughter so that you can remain in the house. The house she used her proceeds of business to build is so pathetic. Man, you are doing a lot. Thank you, but me as a person, I don't get, there are issues I do with my finance by the grace of God. It's so pathetic. I personally brought out money. My IPO have been there on 2 occasions. The moment she will call is around, whether she's relating or the man in a way exchange her SIM or whatever, anytime she make up, before we get there, is out. We will know that we will learn that she has traveled that very moment. I don't know how she's doing it, but with this, I'm sure she'll be able to get justice with you. Thank you so much for doing a lot. And Rula, thank you.
So let's get your response to
Okay,
this.
so
This is the last
what I
question,
just want to say about that is, I'm glad you have that kind of case and you shared it so that people can see just how vulnerable women with disabilities are. And the vulnerability is not just about the physical vulnerability, even emotionally. Society has so beaten women with disability down that you think that an abusive man is better than no man. I know people sometimes oversimplify it and say, well, all women too want men. But in the case of women with disabilities, the stigma is so much that, you know, we self-stigmatize and feel that it's okay to have a man as long as, you know, people can see that our disability did not stop us from getting a man. And sometimes you find yourself allowing all manner of abuse, all manner of wickedness to be meted out onto you. And sometimes it's not because you want it, it's because you have no choice. If you are dependent on him, then how do you even escape? So these are some of the issues, but I'm glad that the police is already looking into it. All I will say is that the person needs also access to counseling, because sometimes you also need to, you know, ingrain inside them that self-esteem, I think, is one of the starting points for many women with disabilities. When you have sense of self-worth, you will know that this thing being done to you should not even happen at all, and you feel free to report it. But she has reported, and so the issue now is left to law enforcement to find the man and bring him to book. And don't be tempted by family members that will come and say, it's a family affair, let's leave it. He helped her, he did her a favor. Please don't even allow that to becloud you're doing the right thing when you eventually find the perpetrator.
Can we give a round of applause to Irene? Thank you. Thank you, and I think that's about it. Sorry, we can't take any more questions, but Irene is extremely, you know, you can meet up with her, ask further questions. We're still going to be networking while we're wrapping things up today. A round of applause again for her. Thank you. Thank you. Thank you for the contributions and the engagement. And you see, I said that I was going to give tickets. I did. Yeah, so we can go. Thank you. So I'm going to be calling the head of Federal Ministry of Justice, SGBV Response Unit, Yewande Bola Awopetu, to give the closing remarks for the day.
Yes. My Lords present, our commissioners from the various ministries of Women Affairs and Health and their representative, civil servants, well, my colleagues here present. We have come to the end of today's program. I hope all of us can go back with at least one lesson. There was a major lesson for those that attended yesterday that many of us could not forget. He said behind every statistic is what? a human being. And then today, I'm sure by when we have the recap for tomorrow, we'll be able to, take something out of today's lessons. In all, we appreciate your presence and we are very grateful. So on behalf of the Honorable Attorney General of the Federation, we call today's meeting to a close and we are grateful for your participation. Thank you so much. We have, I'm sure you all have your meal tickets. And where we are going to have our, where we had yesterday, right? Was it yesterday? Okay. So the commissioners and our VIP guests, they will be exiting this way and the rest of us through the back to the gallery, right? Yes, okay, she will tell that. But please, as all public service meeting, we have to stand up and take the national anthem. That is how we close. Thank you. Please, let's rise up. Media, the national anthem, please.
And also thank you for that training by Grant. You were not around, but it was.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace all battle honor, and this we count as gain. To hand unto our children a banner without stain. O God of all creation, grant this our one request. Help us to build our nation, where no man is oppressed, and so with peace and plenty, Nigeria may be blessed.
Hello, thank you very much. Please lead the, please kindly, our VIPs, please follow Chidima, please, she's waiting. Our commissioner.
Okay, so just a quick announcement. Please, we have someone who made a comment during the course of the conference